for me to mention two matters, Lordship, for upgradation. Lordship, the urgency is that
Upgradation.
Lordship, there is urgency. Lordship, the urgency is that the petition.
Petition hearing.
Petition, Lord.
I
No,
can
Lordship,
I can release the matter.
No, Lordship, affidavit. No, there was a direction by the coordinate bench to
I
file affidavit
appreciate
of opposition.
I appreciate your urgency. I can release that matter.
Till that affidavit of opposition has not been filed, Lordship.
That is a different thing altogether. When it reaches, I will consider.
Only Lordship keeps like.
If you have urgency, I can release the matter. You can try your luck before another bench.
Lordship, one prayer, Lordship. Kindly keep see that for orders so that the affidavit in opposition can be filed, Lordship.
Let them not file. I will take up without the affidavit in opposition. Yes.
With notice I mentioned before, Your Lordship.
Hearing matter.
Hearing matter.
Yes.
Group 1, my lord, one land matter, my lord, I'll be, my lord, kindly includes, my lord. Well, group 1 matter, my lord, land.
Have you served notice?
No, my lord, it has not. Well, it was,
Mention after serving notice.
it was appearing in the list, my lord, before.
This mention after serving notice. Yes,
item number 83, my lord, date is fixed. Would your lordship be going serially or would
serially?
Item number 3.
My lord, I beg to appear on behalf of the opposite party, my lord.
Yes.
My lord, the fact of the matter, my lord, is that the opposite
party petitioner.
My lord,
petitioner is not here.
My lord, yesterday, my lord has specifically stated that it would be on the top of the list. My lord, if I can please the fact, my lord, the picture will be clear. Just 5 minutes of it, my lord.
Give me a minute.
Yes, fine. आपका नाम आइटम नंबर 3 लिख के मेरा नाम एसएन दत्ता फिर आपका नाम दोनों लिख दीजिए एसएन दत्ता फिर आपका नाम
My lord, I am for the petitioner, man. My senior is on the way. He is coming.
Yes.
Sir, my senior is on the way. Sir.
When he will come?
I am led by Edward.
When he is expected to come?
Sir, he is coming, sir. My lord.
How much time it will take?
2 minutes, 2 and 5 minutes. 5 minutes.
Lord, in the meantime, my lord, let me place the matter, my lord. My lord, we are all alone a tenant in respect of the suit property, my lord. My lord,
you are a tenant?
Yes, my lord. Recognized tenant. If your lordship kindly turns to page 39, my lord. page 39, my lord, it filed out that in respect of the property, there was a suit before this honorable court wherein joint receivers were appointed. And my lord, joint receivers has, my lord, issued rent receipts, chronological rent receipts, my lord. In my application, I have annexed, my lord, series of rent receipts that was, my lord, given, my lord, to me by the joint receivers as tenant, my lord. My lord, in page 45, if your lordship comes to page 45 and 46, my lord, your lordship will find out that the electricity meter was also in my name. My lord, what happened? This petitioner, plaintiff, my lord, in a suit, he filed a suit against some fictitious person, unknown fictitious person, and obtained an expertise degree. Thereafter, my lord, it was filed during the COVID exigency, obtained decree, executed the decree, opened the break open the padlock by the order and took possession. And
So you have been, according to you, you are in the property, you have been dispossessed.
I have been dispossessed. So we filed an application, my lord, under order 21, rule 99. That yes, we are a lawful tenant of that. My lord, in that application, my lord, we have given evidence, but during the evidence, my lord, we did not got a paper, my lord, wherein, my lord, the erstwhile landlord has given letters to all of the tenants stating something, my lord. That, my lord, was produced during the cross-examination of the petitioner.
Where is that letter?
My lord, that has not been annexed. I have got a copy of the same, my lord. This is the copy of it.
May I take a respect?
This is the copy of it. That we wanted to confront during the cross-examination. That was the letter given by the erstwhile landlord's advocate to all of the tenants, including myself. My name appears in 8, my lord. To all of the tenants. My lord, this we wanted to confront. During the time when we wanted to confront, they objected to it. The cracks of the matter that they are denying we are lawful tenants. So this was confronted during the cross-examination. Now, my lord, the order is passed, my lord. If your lordship kindly turns to the order, my lord, that is after page 95, my lord. If your lordship kindly turns to page 93, my lord. If your lordship kindly turns to the order implement. My lord, the relevant portion is, I would say 2.6. To counter the submission made on behalf of the, my lord, it is
Where is your application?
My lord, may I submit my case, my lord?
My lord, application is, my lord,
Let me submit. My lord,
my lord.
what happened actually? A lot of things my learned friend have been telling about the particular tenant is not made a party. That's not a thing. I have made the original tenant, who was my tenant. He was being made a party and he has chosen not to appear, and subsequently ex parte decree was passed. Thereafter, the bailiff went to the premises in question, judged all these things were seen, and possession was given. My lord, and criminal case was also started, but subsequently that was dropped because it's the court's bailiff who has taken the possession of the suit premises. Now they were given ample of opportunity to cross-examine. Now they have filed evidence in chief, my lord. My lord will kindly see I have annexed that. I have not suppressed a single thing. I have annexed the bailiff's report. I have annexed the decree. Everything is there. And subsequently, my lord, the evidence in chief of the petitioner who has filed the case is being given. Now that is page 75, my lord. An extra E to the application. My lord will kindly see he has
That is their evidence.
their evidence. They have stated everything. They have annexed whatever documents they want to rely on. Those were there. Now, my lord, after that, my evidence in chief was given. My client, that is the opposite party, was in the dock. Now, suddenly, out of hibernation, all of a sudden, he is being shown a paper. That paper is an extraneous document foreign thing where my client's name does not appear, neither he is a party to that. Now,
Which document?
my lord, the all important September 20
That I have handed
letter, which my learned, the September 26, which was not even given to me. There was no paper was given to us before that. All of a sudden, this letter was shown. Then at that point of time, we have objected on behalf of the opposite party, since this document is totally, this document as best can be proved by the tenant himself. My lord, how can a person prove? My lord, this is beyond the parameters of section 61 and 62 of the Evidence Act. How can a person be produced all of a sudden a document where his name is not there? He is not an author to that letter. Nowhere he is connected. So, my lord, I ask most respectfully a very simple question. Can such a document be exhibited by a person who has no knowledge of it? At best, he could have asked the person who has authored that document to come and depose. My lord, there is no bar in the civil code of civil procedure that a person who has been a document in possession, if original, he can come and produce. My objection was there, my lord. So, my lord will kindly see the order that has been passed.
Yes.
Yes, may I read out the order, my lord? Today is fixed for hearing on the point of maintainability of the document tendered to OP number 1 on the previous date and further cross-examination of OPW1. Both the parties file separate attendance to their respective learned advocates. OPW1 is present. Petitioner is also files the original letter of the month of September 2006 by way of Philisti. Heard both sides regarding the relevancy of the admissibility of the official aforesaid letter in the evidence. Peruse the case record. Considered. It is submitted on behalf of the opposite party's decree holder.
Evidence Act copy also.
Lord, I have brought. Lord, because this is an earlier suit, I have brought the earlier one, but I am carrying the BSA. Exactly the same provision.
It is submitted on behalf of the
The
opposite
provision is same.
Exactly the same. In toto.
Yes. It is submitted on behalf of the opposite parties decree holders that the letter of the month of September 2006, my lord, even the date is not mentioned. Letter, so in my revisional application, I have also not mentioned the date because I have not assessed to that letter as yet. Tendered by the learned advocate for the petitioner to OPW1 during his cross-examination is not at all relevant because it was not issued by OP number 1, nor it was addressed to OP number 1. So OP number 1, OPW1 is not the competent person through whom this letter can be brought in evidence. The petitioner should have brought this letter at the time of the evidence. During the cross-examination of OPW1, the instant letter is merely an extraneous document. This was my submission record. To counter the submission made on behalf of the opposite party's decree holder, the learned advocate for the petitioner referred to order dated 30/9/2021 passed by the Honorable High Court of Gujarat at Ahmedabad in Raghu Bhai Nathu Bhai Kumar Kanaiya versus State of Gujarat Special Criminal Application number such and such. He drew attention of the court to paragraph number 14, page number 5 of the order, where the Honorable Court held that the section 138 of the Indian Evidence Act incorporates certain important principles in the matter of examination of the witness in chief. It insists that the examination in chief and must relate to the relevant facts. The cross-examination, however, is not restricted to the facts which are testified in the examination in chief. As long as it relates to the relevant fact, the cross-examination cannot be confined to any limit. Referring this precedent, the learned advocate for the petitioner submitted that the petitioner wants to establish that he is a tenant in respect of the property involved in the suit. But the opposite party's decree holders filed the suit against some other person and obtained a decree. The letter to which the learned advocate for the petitioner attempted to show the OPW1 is a letter of atonement given by the previous owners of the property to the petitioner and other tenants. So this letter is very much relevant in the instant case. On perusal of the record, it appears that the petitioner filed an instant miscellaneous case under Order 21, Rule 99 and 101 of the CPC. with a prayer for restoration of the possession of the decretal premises on the ground that the opposite party's decree holder filed a suit number 265 of 2019 against a fictitious person and obtained the decree by practicing fraud. The petitioner claims to be the tenant in respect of the decretal premises in the backdrop of the facts stated by the petitioner in the petition under Order 21, Rule 99 and 101 of the CPC. The question as to whether the petitioner is a tenant in respect of the decretal premises or not is required to be determined by the court. So the tenancy of the petitioner in respect of the decretal premises as claimed in the fact is the fact in issue in the instant case. The letter for the month of September 2006, which was attempted to be tendered at OPW1 during the cross-examination, is a letter of atonement issued to the petitioner and other tenants by the erstwhile owners. Letter of atonement is an important incident of tenancy. It can be seen from the said letter that the atonement of tenancy contained therein rules to the decreted premises. As the property in question in the instant case and the property mentioned in the fact in the letter in respect of which the tenancy was to be atoned is same, the said letter cannot be said to be extraneous. So this court finds that the said letter is relevant to the fact in issue of this case and the attention of OPW1 can be drawn to that letter for the purpose of cross-examination. Accordingly, the petition is permitted to cross-examination OPW1 by tendering the letter of the month of September 2006. The written objection filed by the opposite party is not tenable. My lord, by this it was rejected. And even time was not been given. At that time, my client said he is not in a good health. Only then it was adjourned. My lord, my respectful submission is that the opposite party herein got enough of time to produce these letters. Why it should be admitted by a person who is not party to the letter? He has no knowledge of the letter. What is been, because he is the owner, my lord, he purchased the property by court auction. The official receiver appointed in the matter by the honorable court hold as for auction, and my client being a highest bidder purchased this. So he has, my lord, annexed so many letters received of the earlier. Then why not that? All of us, my lord. Then the other question I have in my that can be put on that he has every opportunity to recall his witness. I put that, but what is the general law and under the provisions of the he has to put on the questions what he intends to ask. Put that and file a separate application for that. The doors are not shut, but he wants my client, who is not a party, to admit that document. That's where my client's object. My lord, this is my simple case. So I must respectfully submit such a thing ought not to be allowed, because this is no way related to the dispute in question, because this has other ways to be. I'm not here to advise my learned friend what are the other ways, but even then, this is not permissible according to the Indian Evidence Act. I've taken that ground, my lord, being my ground number 3 and 4. For that, the learned court, by allowing the extraneous document at the time of cross-examination of the OPW without considering the provisions of section 61 and 62, and for that, the learned court, by allowing extraneous document at the time of cross-examination of the OPW1 is in contravention of Order 13, Rule 1 of the Code of Civil Procedure. The document was not produced by the opposite party at the earliest opportunity. Which, my lord, if a person is having a document, he must have used it. That's all mine.
Yes.
Milord. Milord has gone through the matters, Milord. We being a lawful tenant has being, Milord, dispossessed without any due process of law against us, we have filed the Order 21, Rule 99. Milord, the question that has been raised by my learned friend is that we cannot do it because it was his examination and that was not being averted in his case. Milord, if your lordship kindly come, if you takes up 130, I'll only, Milord, place 3 provisions of the Evidence Act. 138 is equivalent to 143 of BSA. Because it was an earlier suit, I have placed Evidence Act. Milord, I am reading from 143. Milord, 143. Order of examination. Witnesses shall be first examined in chief, then, if the adverse party so desired, examined, then, if the party calling him so desired, re-examined. Second, the examination in chief and cross-examination must relate to the relevant fact. But the cross-examination, this is relevant, my lord, but the cross-examination need not be confined to the fact to which the witness testified on his examination in chief. So, in a cross-examination to test the veracity, I can come up with a document. This is
But
the
it has
provision.
to- But it must relate to relevant facts.
Yes, this relates to a relevant fact because they are challenging that we are not a tenant. We want to prove that we are a tenant, always a tenant, lawful tenant. That is the relevant fact, my lord. Only question of dispute is whether we are a tenant.
Except this document, you do not have any other document to prove.
My
your
lord,
tenancy.
all other was produced.
So-
We could not, my lord, at the time when we give evidence, we could not, my lord, it was not, we could not find it out.
Is it a document to prove your tenancy?
This is a document to prove my tenancy because the erstwhile tenant, who were the owners, my lord, they have given that this is a suit between us, so do not pay to any of it. He has stated that you must not pay to any of other parties. So we are a tenant. It was given to all of the tenants, including myself, stating that you do not do. This proves that we are a tenant
Can
always.
this document be proved by a third party to a document?
My lord,
Can this
no, my
document
lord,
be proved?
he can deny, then we'll have the right because, my lord, the question is,
No, ex facie, what he will deny, show that he is a party to this document.
my lord, he was not. He was not a party to the document.
So-
We were.
So you are trying to prove this document through him.
My
To
lord,
get it exhibited, that is your object.
my lord,
He
he
is
can,
not a party to this document. How can it be proved through him?
my lord, my lord, it can be marked. He can deny, my lord, it can be
How
marked
can
X.
it be marked? You have to prove
No,
that.
X. My lord, it cannot be proved. It can be marked X. So we can have the opportunity. There are two provisions, my lord.
If
Two
you have
provisions.
opportunity, you exhaust that opportunity.
No, my lord, we have
He
the
is
right.
stopping you
we-
to exhaust
We have
that
the
opportunity.
right because without confronting this, we will not procure the right of
He is not.
free.
He is not a party to this document. How will confront him?
My lord, my lord, this relates, please. My lord, this relates to the same premises. My lord, if they does not know, they will say, I do not have any knowledge about this letter. So nothing will prove. It will be
Show us
marked
from
as,
this document that his knowledge is imputed. Show us where from.
my lord, his knowledge, I'm not telling that he has got the knowledge. He can deny, my lord. If he does not, I can have the right to confront. He can deny. He has the right to deny and the document will not be marked. Then, my lord, what happened under the Evidence Act? The opening of my re-examination, I have
Show
got
me
the
that
opportunity.
portion of the evidence where you have tendered this document.
My lord,
Show me that portion of the evidence how you have tendered this document to him.
my lord, that portion, my lord, is there in the order impugned, my lord, and my lord, and the
Show me from the evidence. You have
my lord,
Contro-
his evidence.
yes.
My lord, his
You are
evidence
trying
is
to prove this document through him. He is the OPW1.
my lord, OPW1.
Yes, you are
My
trying
lord,
to
OPW
confront
was
him with this
OPW.
document.
My lord,
You are trying to confront him with this document.
my lord,
Show me from the evidence how have you have confronted him with this document.
my lord,
Or you have filed any application in that regard.
my lord, the question is, we have not filed, they have filed that it cannot be done. We have, my lord,
So then you have tendered that document, you have confronted him. Show me that part of the evidence where it records that
my
you have
lord,
confronted him with
the
that
order impugned speaks of, my lord. The order impugned,
document. Show me.
my lord. My lord, the last but one paragraph, my lord, last thing
Of first page.
of the first page of the order.
Yes.
My lord, on perusal of the record, it appears that the petitioner filed the instant miscellaneous case under Order 21, Rule 99 and 101 of CPC with a prayer for restoration of possession of the decretal premises on the ground that the opposite party decree holder filed the eviction suit number 265 of 2019 against a fictitious person and obtained the decree by practicing fraud. The petitioner came to the the petitioner claims to be the tenant in respect of the decretal premises. In the backdrop of the facts stated by the petitioner in a petition under Order 21, Rule 99 and 101 of CPC, the question as to whether the petitioner is a tenant in respect of the decretal premises is not required to be determined by court, is required to be determined by court. So the tenancy of the petitioner in respect of the decretal premises as claimed is a fact in issue in the instant case. The letter of the month of September, this is the letter which was attempted to be tendered to the OP during the cross-examination, is a letter of atonement issued to the petitioner and another tenant by the erstwhile landlord. Letter of atonement is an important incident of tenancy. It can be seen from the letter that atonement of tenancy contained therein
What is the letter of atonement? What do you
this
mean
is
by
not a letter of
atonement?
atonement. This is not a letter of atonement.
This
This
not a
is
letter
not,
of-
not.
So
Milord-
wrong appreciation of a document by the learned court below.
Milord, this is a letter,
On
Milord.
that ground, this was treated to be a relevant document and allowed.
Milord, question is, Milord, I placed that provision. Two
Thank
more
you for
provisions.
saying that this is not a letter of atonement.
Milord, two provisions, Milord, of the Indian Evidence Act. Milord, if your lordship kindly takes up 132(1).
Yes.
132 of the Evidence Act, which is equivalent to 137 of the present Act. 132. Milord, a witness cannot be excused from answering on the ground that an answer will criminate. A witness shall not be excused from answering any question as to any matter relevant to the matter in issue, which has been, Milord, been noted by the learned judge. It is a matter of relevant in issue. Though this appreciation, this is not an atonement. I have to admit, Milord, this is not an at all.
One thing is that if you want the court to enter into that, then have to make observations as to the relevancy of this document in connection with this proceeding. Or you may take your chance in either way. If you want to canvass your case, that is the relevant document, then the court has to render a finding on that.
ने इसको letter of atonement बोला है, but this is not an atonement.
Because you are trying to show these provisions which all relate to relevant facts.
Milord, the question of relevant fact, बोलिए क्या बोल रहे?
If you want, you can make your submissions, then I have to deal with that. Because those observations may come.
Milord, the question is the appreciation of the document was not correctly done by the learned court. That I have to
One way.
admit.
And if you go to the relevancy, you are free to argue. Then I will have to, if you argue, I have to make observations with regard to that.
बोलिए ये documents को Milord, क्या करना है बोलिए. The question is, this is not a letter of atonement. Court is saying the appreciation of the document was wrongly done by the learned court, because this is not at all a letter of atonement, but a letter given by the erstwhile landlord to us, which he is not a party, neither it relates to the atonement of the tenancy. So appreciation by the court is wrong. So whether we place those provisions, because the observation will be made by the court. आप बोलिए हम place करें या ना? हाँ? तो क्या करना है बोलिए. So let it be disposed of. जो भी order. Milord, considering this, Milord, my instruction as Milord kindly considering this, Milord, pass whatever judicial order, Milord saying. So I am not pressing for that. These provisions.
Relevance, you are not going to that.
Milord, the question is, if it is being placed, Milord, even in a
And I have to
recall.
consider and I have to make
Milord, if
observations
it
on
is
that.
being observed
Either
that
way.
it is not being relevant in the matter in issue, then, Milord, even my recalling will not do, Milord, in the lower court. So that would be my predicament in the matter.
No, that can go either way.
Milord,
I'm not saying whether it's
Milord,
relevant or
but
not.
if it is done, Milord,
Yes.
because I am the petitioner there, and if the observation is being made, then even in the recall, I cannot, Milord, do something better. So your lordship has heard the case. Milord, I am not placing this relevant fact, because the appreciation, if it would have been an appreciation in a different way, in the order it has been appreciated as a letter of atonement, which it is not. So, Milord, consider it, Milord. What is the fact is, Milord, that I have been dispossessed even in spite of all the documents which
For that, you have filed that
for
miscellaneous
2199.
case.
Yes.
Get it disposed of at the earliest.
Milord,
With
that
these
we
minor
also want.
issues,
We also
with
want,
these
Milord,
minor
kindly make
issues,
a, that, Milord, I'll submitting, Milord, kindly make it a
since
time
you have
bounding.
documents to show that you are a tenant, you have those
Document was
rent
annexed.
receipts and other things were marked as an exhibit.
Yes, Milord, it
Why
has.
are you trying to delay your miscase in
It has
this
been
way?
marked. It has been marked. All has been marked. Telephone,
So why are you
electric
trying to
bill,
delay your own miscase?
they have filed it. Milord, as your lordship pleases, Milord.
Awesome.
Within 3 months.
Milord, the disposal date, I am praying, humbly praying that some time bound disposal of this order 21.
That will be against you if you want recalling. That may go against you. I can pass that order. If you want, I can pass that order. But
Milord, I'll file a recall. We are trying to do it. We have done it
then
within
the
within
direction for expeditious may
hearing,
go
Milord,
against
as
you.
soon as possible, Milord, because we need it, Milord. We are wanting it to be heard as early as possible.
The no, the order being number 32 dated 7th of October 2024 passed in miscellaneous case number 111 of 2022 by the learned judge, 4th page, Presidency Small Causes Court at Calcutta, arising out of, where is the execution case number? Arising out of ejectment execution case number 17 of 2022
Execution.
is under challenge at the instance of the opposite party in the said miscellaneous case. Opposite parties, parties in the said miscellaneous case. The opposite party got a decree for recovery of possession,
Lordship.
got a decree for recovery of possession, which was put into execution, giving rise to ejectment execution case number 17 of 2022. The opposite party number 1 herein claims to be the original tenant in respect of the decretal property now the
Opposite party number 1 hearing.
who claims to be the a tenant in respect of the decretal property has filed this has filed the miscellaneous case number 111 of 2022 alleging that the petitioner herein obtained a fraudulent decree, fraudulent and collusive,
Milord, yes, fraudulent collusive.
fraudulent and collusive
Without
decree
making in a party.
against a fictitious tenant and got possession of the decretal property by dispossessing the opposite party number 1 therefrom. during cross-examination of OPW1, a letter of the month of September 2006 was tendered by the learned advocate appearing for the petitioner in the said miscellaneous case. For the purpose of bringing the said document into evidence. Such an attempt was opposed by the opposite party in the miscellaneous case, that is the petitioner's hearing, on the ground that the said document could not be brought in evidence through the OPW1 paragraph. The learned trial judge, by the order impugned, permitted the opposite party number 1 herein to cross-examine the OPW1 by tendering the letter of the month of September 2006. Paragraph. The learned advocate appearing for the petitioner submits that the said document is not a relevant, the said document is not relevant to the facts in issue of the miscellaneous case, and therefore the same could not be tendered to the OPW1 during his cross-examination. So, paragraph. The learned advocate appearing for the opposite party submits that the cross-examination, the learned advocate for the opposite party placed reliance upon Section 138 of the Indian Evidence Act 1872 in support of his contention that cross-examination need not be confined to the facts to which the witness testified on his examination in chief. He therefore submits that the said documents can be tendered to the OPW1 during his cross-examination. In course of hearing of this, Taragilithun heard the learned advocates for the respective parties and perused the materials on record. In course of hearing of this civil revision application, the learned advocate appearing for the opposite party number 1 places the said letter issued by the learned advocate of Srimati Kalpana Dhur, THUR, and others, dated 09 2006. The learned trial judge was of the view that the said document is the letter of atonement and therefore is a letter of atonement and as such an important incident of tenancy for which the petitioner of the miscellaneous case may be permitted to cross-examine OPW1 by tendering the said letter. After going through the said document, this court is not inclined to accept such finding of the learned trial judge that the document, that the letter issued by the learned advocate dated 09 full stop 2006 is a letter of atonement. Full stop. The learned advocate appearing for the opposite party number 1, in his usual fairness, also submits that the said document is not a letter of atonement. Full stop. The learned trial judge Section 138 of the Indian Evidence Act states that the examination and cross-examination must relate to relevant facts. Full stop. The learned trial judge was of the view that the said letter being a letter of atonement is relevant to the facts in issue of the case, and only for such reason the learned trial judge allowed the said document to be tendered during the cross-examination of OPW1 by the petitioner of the miscellaneous case. First up, since this court has already observed that the said document is not a letter of atonement, the finding of the learned trial judge permitting the petitioner of the miscellaneous case / opposite party number 1 herein to cross-examine OPW1 by tendering the letter of the month of September 2006 calls for interference. First up, accordingly, the impugned order stands set aside. First up, the learned trial judge is requested to dispose of the learned trial judge, the learned judge, 4th bench, Presidency Small Causes Court at Calcutta, is requested to dispose of the miscellaneous case number 111 of 2022 as expeditiously as possible without granting any unnecessary adjournments to either of the parties.
My lord, only one thing. My lord has stated in the order that it's a collusive. But in the, I have annexed the section, their application, order 21. Nowhere it is being stated collusive.
What is this?
My lord, their statement I have read out. In para 10, page 34, that the opposite party number 2 and inserting the name of a fictitious person.
Only fictitious person?
Yes, only that.
Fraudulent it has been stated.
Fraudulent it has been stated, my lord.
Fraudulent,
Not collusive.
collusive ta kete din.
I am extremely grateful.
Fraudulent and collusive. Fraudulent decree by against a fictitious person. তাই তো? ওই collusive টা কেটে দিন।
My lord, I am extremely grateful for accommodating me because I have an important appointment. I am grateful.
No, thank you.
Great.
Urgent petitioner. Yes, call the next matter. এই লেটারটা না কেপ্ট উইথ দ্য রেকর্ড করে দেবেন।
My lord will be leading my evidence act, my lord. The,
এভিডেন্স একটা only the letter will remain.
my lord.
ওই যেখানে বলেছিলাম
Miller.
না ফাইলস আ কপি অফ দি which is taken on record করে দেবেন। এখন বলেছি ইন কোর্স অফ হার্ড দ্য লার্নেড অ্যাডভোকেটস এর পরেই যে ফার্স্ট সেন্টেন্সটা বলেছি কি বলেছি ইন কোর্স অফ হিয়ারিং হার্ড দ্য লার্নেড অ্যাডভোকেটস ফর দ্য পার্টি এন্ড প্রডিউস দ্য মেটেরিয়ালস প্লেস তারপরেই হ্যাঁ
Part number 1 places the said data issued by the learned advocate for somebody Calcutta rule and others which is 9/2006. The learned charge
which is taken on record করে দিন কমা দিয়ে which is taken on yes call the next matter
45.
none appears for the petitioner at the time of call. No accommodation has been sought for either. Full stop. By the order impugned, the written statement filed after expiry of the prescribed period was accepted without assigning any reasons for without assigning any reasons therefore. Stop. Petitioner is directed to serve a copy of this application upon the opposite parties by registered speed post with acknowledgement due and file an affidavit of service on the next date. List this matter in the monthly list of March 2025. Yes, next.
46.
None appears for the petitioner at the time of call. No accommodation has been sought for either. For the ends of justice, the hearing of the matter stands adjourned for the day. Next.
47.
47, my lords, I am for the petitioner.
Yes.
The only short point for consideration here is in that I had filed an application for substituted service, Order 5, Rule 20, on the grounds that I have served the opposite side twice. And my lords would kindly check page 46 and 50, it says addressee not found. Now, when the learned judge comes up with this in the impugned order, the learned judge is of the opinion that since the addressee has left without instructions, therefore Order 5, Rule 20 cannot be invoked. Now, to the best of my knowledge, that is the address where the defendant used to stay, and there is a suit for eviction.
Civil procedure court.
Well, I'm being led by you, Mr. Lord.
My lord, suit for eviction. My lord, the two attempts have been made to serve at the address where
Civil procedure.
কোন পেজ দেখাচ্ছিস?
4650 বলেছ, তারপর provision জিজ্ঞেস করে, আমি বলেছি তো provision টা কি?
My lord, may I indicate one thing before on facts, my lord? Suit for eviction, the premises was used for the purpose of running a goldsmith shop. My lord, I am the landlord of the particular building or the structure. My lord, I have given notice at the particular address. My lord, I have given notice at the particular address which has been returned as the shop was closed. My lord, the court has gone on the presumption that since no one is residing, my lord, it is not a place of residence, but a shop was being operated, a goldsmith shop was being operated.
আসুন। By the order impugned, the prayer of the petitioner for substituted service was rejected on the ground that return of the registered documents with the endorsement, double inverted comma, left without instructions does not attract the provision of substituted service. Full stop.
My lord, the observation also that he is not residing there would be incorrect because he was only operating a shop.
Full stop. কি বললাম? As কি বললাম? Attract as it is not a case that and as the plaintiff could not establish that for the purpose of avoiding service, defendant is keeping out of the way. Stop.
My lord, may I only draw my lord's attention to the second last paragraph, second last line, where it indicates not residing in the address given in the cause title.
The learned advocate appearing for the petitioner may be justified in arguing that the instant case may fall within the expression double invert comma that for any other reason the summons cannot be served in the ordinary way double inverted comma. Stop. Petitioner is directed to serve a copy of this application upon the again same thing will happen.
Same thing will happen.
Is directed to a copy of this application by registered post with acknowledgement due at the address of the opposite parties by speed post with acknowledgement due and file an affidavit of service on the next date. First up, list this matter in the
My lord,
monthly list of.
My lord, grants me a short date. I will come before my lord, because otherwise it may not be taken up, my lord. My only predicament is I want to complete substituted service. I want to proceed with the suit. My lord, it is not my intention to avoid. The issue is, my lord, the court has gone on the basis that he is not residing there, but it is not his place of residence. Even in the plaint, I have indicated that he
in
was
the week
running a
starting
shop.
from February 24, 2025, or subject to the convenience of the Honorable Court. Next.
48.
Master of Life, my lord.
48, I am for the petitioner, my lord. Petitioner doesn't want to proceed, my lord. Keep to the record.
The learned advocate appearing for the petitioner submits that he has received written instructions from his client not to proceed with this application under Article 227 of the Constitution of India. The written communication addressed to the written communication of the petitioner addressed to the learned advocate on record of the petitioner is taken on record. First up, in view thereof, CO 4161 of 2024 is dismissed as not pressed. Yes, next.
49.
49, this is an application for expeditious disposal of the suit, my lord.
What is the stage of the suit?
My lord, at present, my lord, during the pendency of the suit, my lord, the plaintiff number 1 and some of the defendants were expired, my lord. The plaintiff, in place of the plaintiff number 1, his legal heirs are being substituted. But in the defendants, my lord, the application allowed.
Where are the orders after 2022?
My lord,
You have not
no,
annexed
my
any
lord.
orders after
These-
2022.
Those are typed copy, my lord. My lord, kindly come. This is the last order, my lord. Order dated 15th of July 2023. Just before the page of type copy.
15th of July 2023.
Yes, this is the
What
last
happened
order.
after that? 1st of March 2024. It was
My lord,
fixed.
at present, my lord, that order of there was a direction upon the defendant to comply the application for interrogatories. Matlab, that has not yet been complied with.
So unless the substitution is completed,
Yes,
how
that is
can an
the
order
difficult-
of expeditious
The
hearing be passed?
difficulty is this, Matlab, since 2008, Matlab, it is a 2008 suit. And now it is 2025.
For giving answers and for show cause by the defendants, what happened after that?
Matlab, they have filed their show cause, but till date, Matlab, as on today, what I got information, Matlab,
This is an
interrogatory, they have not
application
yet
for
filed.
expeditious, this is an application praying for a direction upon the learned Civil Judge Junior Division Uluberia District Howrah in title suit number the application ki bolna? Praying for a direction to dispose of title suit number 125 of 2008 expeditiously. First up, record reveals that during the pendency of the said suit, the defendant number 2 died and the heirs of the said deceased defendant is yet to be substituted in the suit. In view thereof, this court is not inclined to pass any directions for expeditious hearing at this stage. First up, the learned trial judge is requested to what happened? Show cause has been filed. What happened after that?
Matlab,
March 2024, you have also not annexed the subsequent order.
Matlab, right at present, Matlab, interrogatories, they have not yet replied to, Matlab. Only the injunction is there till the disposal of the suit.
So you are protected by the order of injunction.
Well, it is a 2008 suit. Well, it is a civil judge junior division fast court Uluberia.
First court.
Fast court.
देखिए. You have not mentioned first court in the cause title.
Kindly give me liberty to.
Plaintiff also first court is not mentioned.
Well, in the order.
The order sheet. First court
the fast court is there.
On the prayer of the learned advocate on record of the petitioner, leave is granted to the learned advocate on record of the petitioner to amend the cause title of the instant civil division application here and now. I mean, yes, next.
My lord, may I tell one thing? My lord, kindly make it not today. May I be come up with the up-to-date information about the stage of this?
Unless the substitution is effected, I've given you liberty. I've said not at this stage.
My lord,
If you have instructions, you can file another application.
I'm getting.
Disposed of, huh?
No,
Next.
50 মানে 50 I pay for not this মানে অনেক তোমার রক্ষিত সিরিয়াসলি হিল মানে অনেক তোমার রক্ষিত পিটিশন মানে I pay for
As prayed for by the learned advocate of the petitioner, this matter after a week. Next.
get for 51
Your Lordship, I'm pleading for the petitioner in this matter. This is a matter for expeditious disposal.
Expeditious disposal of what?
Expeditious disposal of title suit 87 of 2010, which is pending before civil judge junior
What is the
division.
stage of the suit?
Your Lordship, the matter had been decided and then an amendment has been allowed. And the
Order has been?
the matter had been decided. The matter had been decided in the favor of the petitioner. Then the respondents had had filed an appeal. Thereafter, the matter has been remanded back to review in the court of the sixth judge. Now, there has been an amendment in the matter, and the respondents, that is the petitioner herein, are directed to give a additional written statement, but the other side is taking dilatory tactics. They are giving adjournments for without any reasons. Lastly, the last date of the matter was in January itself, and the next date has not come up yet.
It was remanded.
Yes, yes, Your Lordship.
Where is the order of remand? Have you annexed that?
Yes, Your Lordship. Your Lordship, page 40A of the petition, page 40, starts from page 40 of the petition.
What was the suit for?
Your Lordship, it was a suit for there was
Ashun. The petitioner has prayed for a direction upon the learned civil judge within bracket junior division, 6th court at Howrah, to dispose of title suit number 87 of 2010 expeditiously. Full stop. The You are the defendant in the suit.
yes, Your Lordship.
You want expeditious hearing.
Yes, Your Lordship, because it had been decided in our favor. Then again, after being remanded back, the petitioners in the lower court are
The
taking dilatory
opposite
techniques.
party herein. There were two defendants, but you have implemented only one defendant.
Your Lordship, we do not have any contact with the. Your Lordship, I'm taking your leave. I'm led in this matter by Mr. Dhillon Chandra.
Yes, all the parties of the suit have not been implicated in the civil revision application.
My lord, initially, my lord, the the second party is concerned, the defendant number 2 in the suit, a decree has been passed ex parte. Thereafter, the plaintiff filed an appeal. The appeal court held that it should go back. Thereafter, the defendant number 2 is.
How can you leave out the defendant number 2?
Yes, my lord. Defendant number 2 কে পার্টি করা নেই এখানে? মানে that has to be implemented. That has to be implemented.
That has to be incorporated.
Incorporated.
Yes.
Leave be given, my lord, to file
As
appropriate
prayed for by
application.
the learned advocate, for the petitioner, leave is granted to the learned advocate on record of the petitioner to implead the left out party in the costatal of this revisional application, comma, here and now, full stop. The opposite parties herein filed a suit for declaration of title and permanent injunction, being title suit number 87 of 2010. Full stop. The said suit was
dismissed on 19th December 2018.
The state suit was dismissed
on contest. But the impugned order is at 19th December 2018 order is page 18 of
was
my application.
dismissed on contest against the defendant number 2 and ex parte against the defendant number 1 by a judgment and decree dated December 19, 2018. Full stop. The plaintiffs filed an appeal, being title appeal number 11 of 2019, and the learned additional district judge, 5th court at Howrah, by a judgment and decree dated November 22, 2023, sent the suit back on remand to the learned trial judge in terms of the provisions of Order 41, Rule 23 of the Code of Civil Procedure, with a direction to hear the suit afresh on the issue indicated in the order of remand. Mr. Thereafter, an amendment was made.
Yes, my lord. An amendment application has been made by the plaintiff that has been allowed.
Thereafter, the application, after remand, the plaintiff filed an application for amendment of plaint, which was allowed by an order dated 11th of June 2024, and the defendants were directed to file additional written statement. First up, it appears that the suit was adjourned on several occasions, fixing date for filing the additional written statement by the defendants. First up, the last date for filing of the additional written statement was fixed on 16th of December 2024. First up, has it been filed? It has not been filed.
But I have to take instruction because on the last occasion on 24th.
What is the next date fixed?
But as far as the next date is concerned, it is 16th December 2024. It was the last. After filing, thereafter the date has not been given till date.
Taking note of, it appears that the suit was initially filed in the year 2010, and after remand by the learned First Appellate Court, the same is still pending, and repeated adjournments were granted for filing the additional written statement by the defendants. First up, taking note of the peculiar facts of this case, this court is inclined to pass a direction upon the learned trial judge to dispose of the suit within a specified time frame. First up, the learned civil judge, Junior Division, 6th Court at Howrah, is requested to dispose of the title suit number 87 of 2010, which has been renumbered as title suit number 10835/2014, as expeditiously as possible, but preferably on or before the end of September 2025, without granting any unnecessary adjournments to either of the parties. With the above observations, with the above directions, PO stands disposed of, no costs. Next.
Grateful, man.
52.
On behalf of the petitioner, Mr. Dilip Kumar is appearing. His name is Lexo Loss and
Who is appearing?
Mr. Dilip Kumar is appearing. His name is Lexo Loss and Play for not to in this matter.
This is an application praying for a direction upon the learned civil judge, Junior Division 7th Court at Howrah, to dispose of the interlocutory applications filed in connection with title suit number 115 of 2022. To stop, it has been specifically stated in the said application that an application under Order 6, Rule 17 of the Code of Civil Procedure and an application under Order 39, Rule 1 and 2, read with Section 151 of the Code of Civil Procedure are pending. First up, record reveals that what happened on 24th of December, amendment application, record reveals that by an order dated 20th of September 2024, a date, 24, the hearing of the amendment application was fixed on 24th of December 2024. First up, it further appears from the order dated, it further appears from the said order that the ad interim order of injunction was extended till the next date. First up, the learned civil judge, within bracket Junior Division 7th Court at Howrah, is requested to take up the hearing of the amendment application on the next date fixed and to dispose of the same as expeditiously as possible without granting any unnecessary adjournments to either of the parties. First up, the learned trial judge is also requested to dispose of the application under Order 39, Rule 1 and 2, read with Section 151 of the Code of Civil Procedure. Is directed to take up the hearing. Is directed to take up the hearing of the application on the next date fixed, if the same, if the same is otherwise ready for hearing, and to dispose of the same as expeditiously as possible without granting any unnecessary adjournments to either of the parties. Disposed of with the above directions. Next.
Deeply obliged, my lord.
53.
I'm appealing for the opposite party.
My lord, appeal
One,
on behalf
two,
of the
three.
petitioner, my lord, kindly,
You are for the opposite
Parties
party.
want to
my lord,
see
kindly
something.
gives a short pass. My
My lord,
CGN is
this
on
is
his
not
legs, my lord.
maintainable. This is not maintainable.
Why?
My lord, he challenges an order, my lord, whereby, my lord, he seeks reimposition of an injunction that has been refused. My lord,
Challenging an order?
my lord, challenging an order whereby his prayer for reimposition of an injunction, my lord, on recalling an order vacating the injunction, my lord, has been refused.
My lord, small point of law, kindly gives a short passover of 10 to 15 minutes, my lord. Kindly.
Short passover.
Great.
Yes.
54.
54, my lord, I am for the petitioner. My lord, I am the added defendant, my lord, petitioner. My lord, fact of the case is my husband was, my lord, the tenant in respect of the premises in question. Now, my lord, kindly comes to page 10. The opposite party, my lord, plaintiff opposite party number, my lord, 1 to 4 here
Give
is.
me a minute. Who are you in the suit?
In the suit, my lord, I am the
You are
added
the
defendant.
plaintiff.
I am the added defendant. My lord, kindly comes to page 10. My lord,
You are the added defendant.
added defendant in the, my lord, the suit number 45 of 2019. Matlab this
45 of 2019,
in
yes.
that suit, matlab the plaintiff filed the suit.
Added defendant. What is your name?
Shobnam Bhokot. Now kindly comes to page 16. What happened on page 16? My husband during his lifetime filed a suit. My husband was the tenant in the premises in question. Without impleading my husband as a defendant, the plaintiff filed them an eviction suit. Now on the same year, page 16, my lord will find my lord, my husband filed a suit for declaration and injunction that my lord, he is a tenant without due process of law. He cannot be evicted. Now my lord, husband expired. Now after expired my husband, my lord, in that suit 45 of 2090, I filed an application order 9, order 1, rule 10 for addition of parties since my husband was a tenant in the premises in question. That order was allowed by the learned court below. That order is at page 34.
How could you be added as a party in that suit?
My specific case is my husband.
Maybe your remedy lies in your suit for declaration. Get a declaration.
But
how you can expand the scope of the eviction suit?
In that suit, say they the file.
In an eviction suit, the interstate dispute as to who is the tenant, whether the original defendants or the added defendants, that will be decided.
Now, the learned.
You are trying to enlarge the scope of the suit. You are added as a party.
Added as a party, but in connection with the addition of.
I am exercising the suo motu power of revision on this order.
Now, when the learned court below added me as a party defendant, so I filed an application.
I am suo motu asking you to support this order. Court has the suo motu power of revision under Article 227. Even not challenged. How could you enlarge the scope of the suit? What is the impugned order?
Impugned order, I along with my thereafter we file application on 7170. Otherwise, my defense will be struck down. Since I am the original tenant, my husband was the tenant. Now I am became the tenant. Now learned court below by was pleased to allow my addition of party and implemented me as a party defendant in that suit. But my lord did not allow my 7-1 application, consequently 7-2 application also.
Where is your application? On section 7.2.
7.1 application, page 35.
Page 35. Seven two. What is according to you the area rate?
In the 7.1 application, page 35, I have stated উপরুক্ত কারণে বিবাদীগণ 2013 সালে জুলাই মাস হইতে 22 মাস পর্যন্ত such and such আদালতে জমা দিবার অনুমতি দেওয়ার আজ্ঞা।
Why you require permission? Give me a premises tenancy act. The law is otherwise. 7.1 does not contemplate any filing of an application. You have to deposit this amount and within a time limit. So it is, I think, beyond 30 days of your addition of party after you entered appearance, but by limitation.
No, that is not but by limitation. Kindly comes to my by an order dated for being number 44 dated.
It is within 30 days.
Yes. My addition.
Have you deposited the amount within 30 days? You have sought for permission. You have not deposited.
मतलब permission sought for within 30 days.
That is not the law. Do you have a Premises Tenancy Act with you? Premises Tenancy Act 1997 then. And the landlord has not challenged your order of addition of party. Certified copy has been annexed here. Order 1, Rule 10, order.
Yes.
Certified copy is there. All right. I'm issuing your rule. Satisfy why this order should not be set aside.
Order at page 35. 30.
Bring 2003 volume 6 SCC. Suo moto power. Under Article 227. Surja Devi Rai, judgment. Premises Tenancy Act. You don't have a copy of the Premises Tenancy Act. You are come to argue on this issue 7172
Sorry.
by a party who has been added in the suit. ये तो অনেক পুরনো বই, অনেক অ্যামেন্ডমেন্ট হয়ে গেছে। Yes, the law requires payment or deposit. দিয়ে দিন। So 30 days have by now gone by. Law does not contemplate filing of an application under 7.1.
That much calculation part, Malad, I have paid for permission. That the total.
What calculation? That is 7.2. 7.1, you are admitted, not calculation. What you are admitting, you have to deposit.
That is admitted.
So it does not require any calculation. And 7.1 does not contemplate filing of an application. It's only a deposit that you have not done.
Application one of the that is within. That is Malad after. Kindly see 2 dates, Malad.
Your application?
That is within 30 days, Malad. I paid.
Application will not do, Mr. Ghosh. 7.1 contemplates deposit. It does not say application. Application comes in 7.2. If you dispute, no dispute, this is your admitted amount. On a suit being instituted by the landlord for eviction on any of the grounds, the tenant shall, subject to the provisions of this section, pay to the landlord or deposit with the civil judge all areas of rent calculated such and such with 10%. So you are obliged to deposit the areas, not to file an application. Filings in 7.2. If in any suit there is any dispute as to the amount of rent payable, that is only with regard to the dispute. Admitted, no application. Within the time, deposit the admitted amount together with an application. So admitted amount not deposited till date, gone.
Admitted amount, the paid for along with 10% in interest, that is the case.
Admitted amount, but you have not yet deposited. The court also cannot extend the time for that deposit. I am bound by my own judgment, Mr. Ghosh. Court do not have the power to extend this time of deposit. And above all, why your defense will be struck out? The order has been passed under 7.2. That has been complied with. Not by you, by the other tenants. And the plaintiff does not recognize you as a tenant.
My specific case is
Maybe, Mr. Ghosh, the law says 7.1 on a suit being instituted by the landlord for eviction on the grounds. Show that the landlord has paid for eviction on grounds A, B, and C of section 6. If that is not there, section 7 is not applicable. I can keep it for tomorrow. You can come ready with this.
Tomorrow, day after tomorrow.
One night sufficient.
Tomorrow, tomorrow is
Virtual mode. No problem.
day after tomorrow. May I serve, my lord, and kindly fix?
Service.
I'm gonna fix, my lord, another day, my lord.
Service, yes, but I will exercise that suo motu power of that order. I will give you time to reply to that.
So not fix another day, my lord, instead of tomorrow.
The petitioner got himself or herself,
Herself.
only one, only the wife or the son.
No, sons also, the minor
The
sons.
petitioners claim to be the heirs of one. What is the name of your husband?
Bikram Bhakot.
Claims to be the owner, claims to be the heirs of one Bikram Bhakot, who, according to the petitioners, are the tenants in respect of the property, which is the subject matter of an eviction suit being title suit number 45 of 2019. The petitioners got themselves impleaded as heirs of the said Vikram Bhakot in the said suit, in the said eviction suit, and filed an application under section 7 within bracket 1 of the West Bengal Premises Tenancy Act 1997, praying for an order permitting them to deposit the admitted arrears of rent plus 10%. Full stop. Such application was rejected by the order impugned. The questions that arise for consideration is whether a person whether persons who got themselves impleaded in a suit for eviction and against whom no relief for eviction under section 6 of this 1997 Act has been claimed by the plaintiffs in title suit number 45 of 2019 can maintain an application under section 7 within bracket 1 and 7 within bracket 2 of the West Bengal Premises Tenancy Act 1997. Full stop. Mr. Ghosh, learned advocate appearing for the petitioner, prays for an accommodation to assist this court on the next occasion. First up, list this matter on January 30, 2025. Come ready with that. Yes, next.
Hi.
That I am appearing for the petitioner hearing, that is earlier Syndicate Bank, now Canara Bank, and I am defendant number 1 in the title suit 2366 of 2023. My lord, this is a petition for expeditious hearing. My lord, the facts unique in this case.
What is the suit for?
My lord, may come to page number 26 of my petition. 26, my lord, it is a suit filed by a tenant as regards to the and the suit is before third civil judge, third bench city civil court, and the suit is filed by one alleged plaintiff for a property situated at Durgapur, Paschim Bardhaman, and wherein an order dated 1/12/2024 has been passed, wherein staying the operation of the SARFAESI action initiated by the bank against the said secured asset. My lord, this is the third.
The suit is maintainable.
My lord, that is, we have filed Order 7, Rule 11, along with written objection, everything in the month of June after receiving the order. But still now we have been getting dates after dates. My DM order has expired. Liability is more than 4 crore. But learned civil judge is just giving on time after time. Now presently the matter is fixed on 21st of February. And moreover, the suit is barred by the provisions of
in the plain, what they have stated, when the mortgage was created, when the tenancy was created, prior to or subsequent to the mortgage?
My lord, they have written it is from 2009. They have written it is a monthly.
So that's prior to the mortgage or after the mortgage?
Prior to the mortgage, my lord. Prior to the mortgage.
Prior to the mortgage.
But remedy rise in section 17A before DRT, not before the City Civil Court, Kolkata.
Whether the expression any person will cover a tenant,
yes,
whose tenancy was prior to the date of mortgage.
Yes, my lord. Section 17 amended portion 17A.
Yes.
And moreover, the suit is barred by the territorial jurisdiction.
Yes, section 17.
17(4)(a).
Yes.
Any person in an application under subsection 1. Subsection 1 is subsection 1 of section 17, where any person aggrieved can file a petition against the bank for taking steps under 13(4) of the SARFAESI Act. Claims any tenancy or leasehold right upon the secured asset. Debt recovery tribunal, after examining the facts of the case and evidence produced by the parties in relation to such claim, shall, for the purpose of enforcement of the security interest, have jurisdiction to determine whether lease or tenancy has expires, to determine in contrary to to determine or in contrary to 65A of Transfer of Property Act, in contrary to the terms of mortgage, is created after issuance of 13(2). All the things are covered by the amended provisions.
Where is the order sheet showing that this order 711 has been fixed? When?
My lord, may just see the order, impugned order passed. That is.
You are challenging any order, or you are?
No, I am asking only the trial court to hear me.
Yes, yes. Where is the order sheet fixed?
My lord, the last portion, order sheet.
19th of July, it was fixed for hearing of order 711.
19th of July. Then on, it is continuing. Presently also two dates after 2 months, dates are being fixed, but court is not having time. Presently, the matter was again taken up of 21st of January. Again, same thing happened. It has been fixed on 21st of February. Where the suit itself is not maintainable. My lord, how? My lord,
21st of February?
2025.
For
hearing under order.
For hearing of what? Order 711.
But again, that day something or other thing will happen. My petition will not be heard. And my lord, the strange thing is this is the third suit filed by the tenant of the same property, incorporating the defendant number 2 therein, that is the original borrower. He is in connivance acting. This is, if my lord sees I have annexed the 3 suits. This is the third suit, 2021 and 2022 and 2023.
What happened to the other suits?
Other suits are presently dismissed. In this suit 1812, on the first day when we brought to the notice that the property tenancy right has been sought on the property situated at Durgapur, then and there the petition it was rejected. That is the order passed in 1812 of 2022.
This is an application praying for a direction upon the learned judge, third bench, City Civil Court at Calcutta, to dispose of the application under Order 7, Rule 11 of the Code of Civil Procedure filed by the petitioner herein in title suit number 2366 of 2023. First up, they have filed written objection. Yes.
They have filed written objection long
Record
back.
reveals that the opposite party herein has also filed the written objection against the application under Order 7, Rule 11 of the Code of Civil Procedure. First up, from the order sheets annexed to the civil revision application, it is evident that 19th of December 2024 was fixed for hearing of the Order 7, fixed for hearing of the application under Order 7, Rule 11 of the Code of Civil Procedure. First paragraph, the learned advocate appealing for the petitioner submits that till date, on that date, the hearing of the application under Order 7, Rule 11 was adjourned, and the next date has been fixed on
21st February 2025.
21st of February 2025. First up, in view thereof,
My certain humble prayer is certain observation be passed. This is very unique.
With regard to merits, no, madam. In view thereof, CO 4168 of 2024 is disposed of by requesting the learned.
My lord, request no direction. We have already expired 2 times DM order. We cannot access. If the matter is not heard, then our section 14 order will also go, my lord. We are suffering injunction from 2023.
The learned judge, third bench,
2024.
City Civil Court at Calcutta, to take up the hearing of the application under Order 7, Rule 11 of the Code of Civil Procedure on the next date fixed, and to dispose of the same as expeditiously as possible without granting any unnecessary adjournments to either of the parties.
Grateful, my lord.
Next, no cost, photostat certified copy. Next.
56.
None appears for the petitioner at the time of call. No accommodation has been sought for either. For the ends of justice, the hearing of the matter stands adjourned for the day. Next.
53.
Wait.
57.
57, my lord, I am appearing for the petitioner, my lord, in this matter. My lord, I am the defendant Bharatiya, my lord, in the lower court, my lord.
Defendant Bharatiya.
Yes, my lord.
Thika tenancy.
Yes, my lord. What happened, my lord? The plaintiff, my lord, filed a suit for eviction, my lord, without disclosing the fact that this is a Thika tenant property. My lord, I have filed, my lord, an application under Order 7, Rule 11, my lord. And there, my lord, I have annexed this document which shows, my lord, kindly comes to my
Order 7, Rule 11 is rejected.
Yes, my lord, rejected. My lord, kindly comes, my lord, to the order 7, my application under order 7, rule 11, my lord. Where, my lord,
Rightly so. That will be decided in the suit. Produce all the relevant documents
my lord,
in the evidence. That cannot be decided.
my lord, kindly see the document, my lord.
Next question of law and fact, rightly held.
My lord, kindly see, my lord, in the plaint, my lord, the material facts has to be pleaded. My lord, the plaintiff, my lord, have intentionally suppressed the fact that this is a Thika tenancy property. My lord, because, my lord, I say, so because
That is a mixed question of law and fact. Suppression cannot be decided. Show me from the plaint itself that the suit is barred. It is to be bare reading of the plaint itself. Other documents cannot be looked into.
yes, my lord, but another
For the
fact,
purpose of rejecting the plaint, it may be otherwise. For the purpose of saving the plaint, some other documents may be looked into, but not for the purpose of rejection
but my
of
lord,
plaint.
my contention, my lord, is, my lord, when there is a material suppression of fact, my lord, when he
Proves
himself,
that in the suit.
my lord, me,
The by the order impugned, the
my lord, may I bring a judgment, my lord, on that point? When there is a material suppression of fact, my lord, when he himself has pleaded the point of Thika tenancy in a different suit, that is pending, my lord, before the same
that
court,
plaint is to be brought.
my lord, the plaint.
How the court will look into the plaint unless it comes to it is produced, tendered in the evidence. Can it be decided in Order 7, Rule 11? Madam, do you have a copy of the Civil Procedure Code? Kindly take up Order 7, Rule 11. You are invoking Order 7, Rule 11, Clause D.
Clause D, my lord, and
Clause D.
My lord, and clause 1, my lord, also, my lord, non-disclosure of cause of action, my lord, because, my lord,
Show me
when,
from the plaint itself, it does not disclose a cause of action. Show me.
my lord,
It
that,
has to be on a bare reading of the plaint, nothing more.
my lord, when there is a,
Some statements made by you in the application, some documents, court cannot look into that. Show me from the plaint, it does not disclose a cause of action. Yes, I will accept that.
my lord, my contention is, my lord, when there is a suppression of material facts, my lord, kindly comes to Order 6, Rule 2, my lord, where the material facts has to be pleaded, my lord. But here, my lord, despite knowing that this is a Thika
The
tenancy,
ground for rejection of plaint.
my lord, may I find some judgments on that point, my lord?
Tomorrow, after some argument, the learned advocate for the petitioner prays time to place certain judgments in support of his contention that material suppression of facts can be considered while deciding an application under Order 7, Rule 11 of the Code of Civil Procedure. That is your submission? Yes. Next. Call the next matter.
58. I'm the petitioner, my lord. Defendant petitioner assailing an order passed under 115A.
Assailing an order passed under Section 115, capital A. What was the original order?
There was a, may I, my lord? There was a suit under Bengal Moneylenders Act, 36 to 39. Suit decreed ex parte, declaring that a registered sale deed is a mortgage by conditional sale, and there's a preliminary decree passed. Final decree was directed to be drawn up. Final decree proceeding dismissed for default. After 13 years of the preliminary decree,
what was the order under challenge in 115 capital
challenging the maintainability of the execution proceeding. That was admitted by the learned district judge at the time. The admission
maintainability of the execution petition.
Execution proceeding, since the my lord, the final decree proceeding has been dismissed for default. At this
Show me the order passed by the trial judge or the executing court.
My lord will find that order dated 17th of page 43.
43. No, the initial order which was challenged in 115 capital A,
My lord.
it only decided the maintainability issue.
Maintainability issue.
Here on merits it has been decided.
No, here on merits it was decided. On the merits of the
trial court did not go into the merits.
The trial court did
It only decided on the
constructive res judicata rather.
Yes.
Now, at this current moment, there is no final decree. So execution proceeding has to be instituted on a final decree. My lord, kindly comes to page 26 for once. Page 26, that is the dismissal of the final decree proceeding. My application for rescission of the preliminary decree is still pending. Page 26 is the dismissal order, my lord.
Page 26.
My lord.
Yes, suit is dismissed for default.
That's the final decree proceedings.
Yes.
Dismissed for default. After 2 years, instituted execution proceeding without there being any final decree. How can it continue, my lord?
How it has been dealt with by the learned trial judge?
There was a previous application under 47 challenging the executability, discharge and satisfaction. That was turned down by the trial. Miss case was registered, that was dismissed. Since I have filed the 47 application, the constructive res judicata bars me from filing an application challenging the maintainability since there was, that is the only order.
Maintainability on what ground? Same ground.
There is no, my lord. Maintainability 47 deals with
is also challenging the executability.
Execution, discharge, satisfaction.
Yes.
The maintainability is, my lord, at this current moment,
That is also in execution. It's all with regard to execution.
At this current moment, there is no final decree. Admittedly, there is no denial on that part.
The earlier order attained finality.
No, my lord, I have challenged that. Subsequently,
you have not challenged the earlier order.
The miscase order was not challenged. I have annexed the miscase order.
Then it has attained finality.
Even the execution will continue without a final decree proceeding, my lord.
You have not challenged that. The earlier order you have not challenged that.
That doesn't make a wrong or right, my lord. In my humble submission, if the execution proceeding cannot continue without a decree, that was not dealt with by either of the courts. And I have the order of admission of the 115A, my lord, I have not. Even the 47 was dismissed, holding at this stage the
Why
executing.
instead of challenging that order, you filed another application for maintainability?
Even at the 47, the court comes to a conclusion. At this stage, the executing court has no jurisdiction to entertain the instant petition under 47. Since it cannot go behind.
Court has no jurisdiction that order.
My lord, page 32, it starts. Page 33, concluding part, my lord. Since the court cannot go behind a decree, it cannot. There's no decree at this current moment. That is the only thing I was trying to portray before the learned trial court, executing court.
Show me their execution application.
The execution application is not there. Even in the execution application, one of the defendants has not been made a party. One of the judgment debtors have not been made a party.
That is not a ground.
No, regardless, my lord, the execution application is not. It's a rather old record, my lord. I could not obtain the certified copy of the execution. I have the judgment decree, my lord. Preliminary.
But if there is no.
At this current moment, admitted position, there is no decree to execute. The preliminary decree cannot be executed. Final decree has to be drawn up. There is no final decree. The execution proceedings will continue on the basis of a preliminary decree which has not come into a finality. That is the only thing I'm trying to portray. Even both the courts.
Show me that you have raised that point in the in 115 capital A.
Maintainability petition starts at page 35.
No, you have raised that. Show me from the order impugned.
No, my page 36, my application is
Show me
there.
from the order
Order
impugned that you have pressed that point.
My lord.
And how it has been dealt with.
My lord. One. It only deals with the fact that since the earlier miscase under 47 has been dismissed off, I'm barred by constructive res judicata.
Show me the preliminary degree.
My lord. Starts at the plane starts at page 11. The decree is at, my lord, page 16.
Page
16. 16.
16.
16. Decretal portion is page 18. Hence ordered. Only on that score. The final decree does not exist. The execution proceeding cannot continue, could not have been initiated rather.
Bring the execution application.
I shall, ma'am.
Awesome.
May I prefer a stay of execution proceedings? It's
bring the tomorrow.
my lord, tomorrow, my lord. My lord,
after tomorrow?
Friday. Friday.
As prayed for by the learned advocate for the petitioner, list this matter on January 30. 31. Friday, you said?
Friday, my lord.
31, 2025, under the same heading. Petitioner is directed to produce the copy of the execution application on the next date.
I'm good.
Yes.
59.
On the next date.
Lordship, the advocate on record appearing on behalf of the petitioner is presently unwell. That is presently unwell, Lordship. For that reason, he is unable to come to the court, Lordship. I am praying for an accommodation on this ground, Lordship.
As prayed for by the learned advocate for the petitioner, hearing of the matter stands adjourned for the day. Call the Passover matter.
53.
Lord, I have a preliminary point of maintainability.
But may I just, in brief, my lord, just summarize in brief what the case is?
Before
Placing the
maintainability.
But for maintainability, my lord, basic facts will have to be, my lord, put forward.
What is the order impugned? Show me.
My lord, the order impugned is at page 129. It's an order dated 25th September 2024. My lord, I am the developer.
Give me a minute.
Remember to give this.
Show me your 151 application.
And that is
Yes.
at page 118.
118, my lord.
Or my lord, Bengali version is at 116 prayer.
118. My lord, may I?
Type copy.
My lord, 100, just allow me to assess the
This is my
please.
point of maintenance.
Sure. Okay, fine.
Well, kindly looks at the prayer of the my lord application. 116 in Bengali. My lord, may I place the prayer? 116. সে কারণে অত্র দরখাস্ত করিয়া প্রার্থনা যে হুজুর দয়া পড়িয়া উক্ত কি উক্ত সামথিং মিলট বিবরণের বিবেচনা
দরখাস্তের বিবরণ
বিবেচনা
করত
নট ক্লিয়ার
difficulty in reading Bengali I
নট ক্লিয়ার হিয়ার করত ন্যায় বিচার স্বার্থে গত ইংরাজি 26/2/2024 তারিখে 26/6/2024 তারিখের আদেশ রদ ও রহিত করত পুনরায় নালিশি সম্পত্তির অ্যাড ইন্ট্রিম ইনজাংশনের আদেশ করত তৎমর্মে যথা বিহত আজ্ঞা হয় বিহিত আজ্ঞা হয় So my lord, it's reimposition of the injunction. My lord, on recall of the earlier order.
Yes. How it is maintainable?
My lord, I prefer the suit. In that I am the developer, my other side is the landowner. Out of 4 floors, I have constructed 3 floors. At which time they begin to, my lord, obstruct with my construction work. In the meantime, I've also
Don't go into the merits. Only on the maintainability.
May I, my lord? My lord, then my ad interim order, my lord, which was granted, was extended from time to time from 2021 to 2024. No application filed under Order 39 Rule 4, no written objection filed to the interlocutory application, no appeal preferred against the order, never under challenge in any form. In 2024, my lord, on one fine day, my advocate on record preferred an application for extension of the interim order. Then he fell sick. My lord, he had to undergo for treatment. He sent his junior, who was present. It's recorded in the order that the junior is there, but the actual person who holds the wakalatnama is not present. For my lord, want of presence of the advocate on record, my lord, even though the junior was there for the extension, petition filed for extension, my lord, the interim order was vacated. No objection, written objection filed to the interim application. It's my lord to recall that order that I preferred an application under section 151 of the
And what is your prayer?
Code of Civil Procedure.
What is your prayer? After recalling, we have prayed something more.
My lord, it's
you have prayed for injunction.
My lord, recall and reinstating.
So effectively, you have prayed for injunction. So,
my lord,
you may technically submit that you have prayed for injunction under section 151.
My lord,
Order 43, Rule 1, Sub Rule R may not stand in your way. Is it your argument?
My lord, that this ought to
your
be
argument. I'm asking you.
Come again, my lord. I'm sorry. My lord, I just missed what your lordship said.
This was application styled as 151.
Yes.
Not under Order 39 Rule 1.
Not under Rule 1 and 2. For recall of
technically, Order 43 Rule 1 Sub Rule R.
Yes.
Does not stand attracted in this case.
I don't have.
Is
Yes.
it your submission?
Yes, my lord, that I can't go in appeal, which is why I'm before your lordship.
Fortified with any decision in your support of this proposition?
My lord, it will fully, my entire case, my lord, is based on the interpretation of this prayer. If this, because my lord, it is very well settled that heading of an application doesn't decide what the nature of the application is, the contents of the application. I'm completely, that is very well settled, my lord. Therefore, my lord, in view, my lord.
So what is the contents of your application?
May I?
Is you have sought for prayer and prayer for injunction.
No, my lord, may I attempt, my lord, to make my case. This is the impediment which I was anticipating, but my lord, it can be overcome. My lord, if this, not just prayer, the entire application, my lord, ought to be read as a whole. Now, my lord, if I was to make an application for injunction, then, my lord, I would have to state all facts of the case. I would have to, my lord, make out, my lord, what is my balance of convenience, irreparable injury, and then accordingly, my lord, press for an order of injunction. In the facts of this case, my lord, an interlocutory application under Order 39 1 and 2 was preferred. An order was subsisting. And my lord, I am not making any new prayer. The prayer is already there in my pending interlocutory application. In fact, my lord, by the order whereby my interim application was vacated, I was also show cause to say why my main application under Order 39 Rule 1 and 2 should not be dismissed. I will show that to your lordship. So, my lord, it can't be construed that I would again, my lord, go and ask, my lord, for the same thing which I've already asked for. This is, my lord, simply, my lord, an application for vacating, resurrecting my lord, dead order. In the sense, vacating, my lord, the order, recalling the order.
The order of vacating the.
Recalling the order, I'm so grateful. Recalling the order whereby the interim order was vacated and reinstating the order. My lord, the reinstating, this has to be interpreted, my lord, as reinstating. Because kindly look at, my lord, 4 paragraphs in the application. Kindly, my lord, see what have I pleaded here. My entire cause of action, entire pleading, my lord, has to also be taken into, my lord, consideration here. So, my lord, if I may place this 118. As per direction of the learned court, the plaintiff has issued summon and service upon all the defendants, and the defendants have already appeared before this learned court and are contesting the suit. The plaintiff has filed an application for extension of an ad interim order dated. Now, my lord, the language is flimsy. I am not coming. My lord, there's no two ways about it. What is there is there. Interim order of injunction before this learned court on 26 June 2024, but due to sudden illness of the plaintiff, he had to go back to his house for medical treatment. At the time when the matter was called, the plaintiff nor his authorized representative was present, and as such, the learned court passed the order directing the vacating of an ad interim order of injunction. Unless the order for ad interim injunction is not restored, kindly, my lord, see the pleading, restored, the plaintiff shall suffer irreparable loss and injury as the defendants would change the nature and character of the scheduled property so and so. By nature of the character scheduled property during the pendency of the suit should not be changed. And then, my lord, the prayer, under these circumstances, it is prayed that your lordship will graciously please to recall the order dated so and so, and again pass the order of ad interim injunction. My lord, the language could have been better. I'm not coming in the way. But if your lordship sees the essence of the application, my lord, in congruence with the pleading, it is for restoration. It is for restoration of the subsisting order. This is not, my lord, for granting any new relief, because my application under Order 39 is pending. So if I have prayed for a new injunction and it has been refused, I understand, my lord, there is a remedy of appeal. But if it is only for restoration, then, my lord, this remedy is here. So the entire question, my lord, comes down to whether, given the facts of the case, read with my pleadings, and, my lord, the prayer, what is a reasonable presumption of, my lord, the pleading when the language is not, my lord, very clear? It is clearly restoration, is my humble submission, my lord, and not any fresh order of injunction. And I'm willing to, my lord, even submit on instruction that the limited scope of this application was, my lord, to restore the existing order of injunction, not to get any fresh or new order of injunction, because the application under Order 1 is not disposed of or dismissed. It's still pending. So, my lord, if that's the construction, then, my lord, my remedy is before your lordship.
If in a hypothetical case an application under Order 39 Rule 1 and 2 is pending, but an ad interim order of injunction is vacated under Order 39 Rule 4.
Yes.
What could be the remedy as per the civil procedure?
My lord, yes. If it is vacated, then, my lord, of course, I have a right of appeal. I have a right of appeal. No, my lord, but
it was vacated,
my lord,
for whatever reason. Ultimate order is vacating.
No, my lord.
Because right of appeal is against the ultimate order,
My lord.
not the entire reason.
My lord, if it is
maybe the grounds of appeal.
My lord, if it is
But appeal
vacated,
lies against the order.
my lord, if
which
it is
the
vac-
ultimate decision.
I am with your lordship. My lord, if the order is vacated on merits, if they file an application for vacating of the order, if the court hears the application, because Order 39 Rule 4 deals with, my lord, me misleading the court, suppressing things before the court, which then the party enters and then points out these things. And on merits, if the court finds that yes, the order should not have been passed and I'm vacating, then against that, my lord, I'll go in appeal. But if that is not so, if I have merely, my lord, for inadvertent reasons failed to appear, and for lapse of, my lord, following up in the matter, for non-prosecution.
Decisions in support of yours, this contention. You are nodding your head like this.
My lord,
there are judgments I can.
Milord, there are Milord, old decisions. Milord, I know, Milord.
He's nodding his head this way.
I can try and bring. I have frankly haven't been able to look up. But I'm sure, my lord.
Now we have entered appearance, we have filed our written
My lord, while researching
in the suit, main injunction against the main injunction application.
Let it be heard. Fixed.
Next date ta
You have two choices, because this has to be either is to be decided one way or
12th
the other.
February.
Or if Mr. Chatterjee's objection is accepted, then you have to go before the appellate court, file an appeal thereafter, or if the date has been fixed, because this was against ad interim, I can direct the hearing of the temporary injunction.
In the meantime, my lord, they will not do anything which will defeat the purpose of my case. Because if
that is in any way admitting your case and passing an order of injunction.
My lord, because in the interim, if they do something, if they get into another, my lord, agreement with some developer,
they could have done in the meantime. Prior to this,
nonetheless,
vacating and till today, if they have done anything, done.
Nonetheless, my lord,
kindly. What is the next date fixed?
Kindly.
12th February. We're not far.
Very
12 days.
near. You can take your decision. 12th February, I can direct the learned trial judge to take, because the petition has been filed. Application is ready for hearing.
We have no difficulty in hearing the doing the matter. In fact, we would, my lord, be grateful if that order is passed, that the hearing is done on the 12th of February. We are not shying away at all from having the matter heard on merits insofar as the interlocutory petition is concerned. But, my lord, there was an interim order in my favor, which had been running, my lord, for 3 years.
Vacated when?
The interim order, my lord, was vacated. Just a moment, my lord.
June 2024.
June 2024.
June 2024.
Yes, my lord.
So today we are on January 26th January 2025.
26th June 2024.
7 months you could wait.
My lord,
without an ad interim order.
I have not waited, my lord. I have always, my lord, at all points in time.
You were without an ad interim order.
Without an ad interim
7
order.
months.
But, my lord,
and 12th of February.
But, my lord, there are decisions.
Then I have to decide it on merits.
Yes, my lord, there are
Take his decisions.
there are subject to correction, of course. There are, my lord, a line of decisions that pending a matter where an interim order has expired for lapse of time, if some party takes an adverse step, then the courts have come down, my lord, heavily on those parties. But after your lordship passes,
advantage of those decisions if they do something.
No,
advantage of those decisions if they do something.
No, but after your lordship's order, which I'm, my lord, being suggested to, my lord, consent to, of expeditious hearing, but, my lord,
not a way of consenting. I have asked you whether you are willing to accept that. If you want to press, I will decide this. No issues on that.
This will keep pending. Injunction, let the injunction be heard of.
Mr. Chatterjee, let him take his own decision. You are his adversary. Why are you trying to impose something on him?
my lord, I have to take instructions. In fact, just like the trial court, my advocate on record is not there today. He's in Tripura. I believe he's entered online, but I'll have to take instructions. I don't even know who the client is, frankly. I've never met them.
You can argue on merits then, no problem.
No, but since it has fallen from your lordship, that the matter can then be heard out as a preemptory direction.
That is already there, because if the 12th is there, that can be directed. You can proceed with this on merits also.
Then would your lordship then take it up at 2 o'clock, my lord? In the meantime, I'll take instructions from my client and the advocate on
2 o'clock subject to the division bench.
It keeps it tomorrow
Or
first
tomorrow,
matter.
tomorrow first matter, my lord.
That's to be mentioned, my lord.
Ashun. After some argument, the acha likhun. Sir, again.
May my affidavit of service be taken on record, my lord.
My lord, we are on caveats, my lord. Caveator, my lord.
Mr. Chatterjee, learned advocate appearing for the opposite, all the opposite parties.
No. 1 to 6.
Appearing for the opposite party numbers 1 to 6 raises a preliminary objection as to the maintainability of this application under Article 227 of the Constitution of India. First up, by the order impugned, the application under Section 151 of the Code of Civil Procedure filed by the petitioner herein praying for vacating the order recalling the ad interim order of injunction and for passing an ad interim order of injunction stood rejected. First up,
Next day.
the learned advocate appearing for the petitioner takes time to undertake some research work on this legal issue and to revert back to this court on the next occasion. As prayed for by the learned advocate for the petitioner, list this matter tomorrow.
My lord, I have tomorrow morning, I have to go to NGT for one matter, my lord.
That cannot be a ground, Mr. Chatterjee.
I know, my lord, but I would be fair and, my lord, to my lord. My lord,
Entire day he will
no,
be
no,
there.
my lord, I come back, my lord, by 1 o'clock. It will be over by 11:30 by the time what it takes.
Let it appear thereafter. You are taking a chance since he has, for him, you had to wait. So for you, he has to wait tomorrow.
No,
This
not
the
like
strategy,
not,
Mr. Chatterjee.
no, not like that, my lord. My junior remembered me, my lord, made me remember of tomorrow's statement. I
So
forgot.
for him, you had to wait. So you will make him wait tomorrow. Tomorrow under the same heading. If you are in difficulty, at a key, affidavit of service you are filing today.
Yes, my lord.
Affidavit of service filed in court today is taken on record. Yes. হয়ে গেল তো সব কটা হ্যাঁ ডাকুন
দিয়ে দিচ্ছি আমার নাম দিয়েছি হ্যাঁ দেবো
Item number 62, assign matter.
Madam, I'm for the state matter.
Yes.
Earlier officer will not
Lordship.
directed to submit the report, madam.
Lordship, 6th January. 6th January, Lordship of this Honorable Court was pleased to submit the report.
Yes. Pursuant to the Ashun, give him a copy. You have given him a copy.
I'm giving my lord.
Pursuant to the order dated 6th of January 2025, the report of the Sabadipoti, Purbo Medinipur Jila Parishad dated 24th of January 2025 has been filed in court today, which is taken on record. Let a copy of such report be supplied to the learned advocate for the petitioner in course of this day. First up, it appears from the said report that the demarcation process has been completed and steps will be taken in accordance with the provisions of the West Bengal Public Land within bracket eviction of unauthorized encroachment bracket closed Act 1962 in case of any unauthorized occupation in the land in question. Full stop. List this matter after 3 weeks. On that date, the Sabadipati Purbo Medinipur Jila Parishad is directed shall file an action taken report on that date.
Or 2 weeks, lots of, because of petitioner is.
Yes. Next.
63. 63.
And for the
Same
statement,
order.
this is a report, my lord.
Report.
Ashun.
Actually, I am
Same order.
I am praying.
Order report date is also same. 24th of January 2025. Yes, same order.
Demarcation has not been done, my lord. Second page, my lord.
Once the demarcation is underway.
Underway.
All right. No, in the earlier matter, देखिए 1 minute. In the earlier matter, the demarcation has been done. देखिए आगे ऑर्डर 1 minute আসুন তো আগের অর্ডারটা যেটা বললাম না, from the said report it appears that the demarcation process is completed বলেছি তো from the না in the ওটা কেটে দিয়ে লিখুন in the report, in the said report it has been stated that once the demarcation process is completed the পূর্ব মেদিনীপুর ঠিক আছে will proceed ঠিক আছে তারপরে যা আছে ঠিক next same order.
Fix a short date, please. Because
yes, demarcation is yet to be completed. Do you have any practical idea how demarcation is conducted? You have a practical idea. Even then you are saying 3 weeks is more.
Because petitioner is suffering a lot.
You have any practical idea how demarcation of land is takes place?
So survey is important.
Yes. So that is why I'm asking you, do you have any practical experience of that?
I know survey something.
How much time it takes? What is the procedure for demarcation?
Administration can do expeditiously, but
yes, next.
Grateful, man.
64.
64.
So report I am praying.
Give him a copy.
Not grateful.
64, my lord. That matter, my lord, victim has come before you. My lord, affidavits are exchanged. This is my reply. Affidavit in reply.
It is to be heard.
My lord.
All right. Affidavit in reply filed in court today is taken on record. When do you want? Next week?
Next week again, my lord, Chief Justice, my lord, in this week, not, my lord, possible, my lord. Only 15 minutes required, my lord, 10 to 15 minutes.
It's a problem because the motions are there.
Next Monday, my lord, Chief
This
Justice.
is a hearing matter. It is to be heard. It will take some time.
Next Monday, my lord.
Next week, I am keeping it.
But availability of your lordship.
That is there. Kiola, affidavit in reply filed in court today is taken on record. List this matter in the next week under the same heading.
My lord.
Next matter is restoration matter. Restoration for my land friend is here. We have to restore the matter.
Restoration. What is the main matter? Huh?
Main matter is, my lord.
Yes, Din. 60 for fixed matter. 60.
Oh, 60.
Yes, 60.
65. What a fixed
I'm for the petition.
Next,
I'm for the
next.
Item number 60, I'm for the petitioner, my lord.
61.
61, my lord, I'm there, my lord.
Yes.
61, my lord, it's an application for expeditious disposal, my lord.
Expeditious disposal.
Yes, my lord, I am the plaintiff, my lord. I have filed the suit of an order of injunction, my lord. Thereafter, I have filed an application under Order 1, Rule 10 for addition of
Yes, ये बोलो था.
I have filed application for addition of parties, my lord. There are 2 applications pending for addition of parties, my lord. I'm praying for expeditious disposal of those 2 applications, and my lord, the judge has fixed the matter after 13 months from the last date, my lord.
The application under Order 1, Rule 10 was fixed for hearing on?
Lastly, it was fixed for hearing on 26/9/2024, my lord. 26 September 2024. There are 2 applications, my lord.
Yes, what happened on that date?
My lord, my lord, it was simply adjourned, my lord. And the matter is fixed in the month of October 2025, my lord.
October 2025.
I have filed the e-court as well as the order, my lord. The order is not paginated, my lord, because it's an impugned order, my lord. My lord, at the last after page 44, my lord, it starts 44, 45, my lord.
Where is the order sheet that it has been fixed on October 2025? From September 2024, it has been fixed in October 2025.
Yes, my lord. I have filed the e-court, my lord. It's in page 44, my lord. The
Page?
44, my lord. 44. I filed the case status from the e-court, my lord. My lord, kindly sees 45, page 45, my lord.
Yes, yes.
Yes, it's fixed on 16th October 2025, my lord. I only want my Order 1, Rule 10, 2 applications to be heard, my lord. That's because
But the date cannot be preponed without hearing the other side. I can
no,
do
the
one
other
thing, I
side
can
has
give
not
you.
appeared, my lord. What has happened, my
Maybe,
lord?
but preponing, they may be watching.
My
They
lord,
may be watching.
my lord.
I can give you liberty to apply for preponing before the learned court below. Or you have to serve.
My lord, what has happened, my lord? The defendants against whom the suit filed, they have sold the property to the third person. I only wanted, since the defendant have not appeared, I want to add those parties as defendants also. I'll serve them. I'm undertaking to serve them. But if they are not added, my lord, how will I serve them? This is the suit I filed, obtain injunction
For
order.
the remaining defendants, you have to serve.
They until unless they are added, Your Honor, I can't. I have served the defendants whom I made party. In the meantime, during the pendency of the they sold property.
Preponing cannot be done by this court.
My
Either you have to serve or I can give you liberty to apply.
orders, I'll serve and come this application, my lord. Then I can do, my lord. Kindly fixes the shortest possible date.
The learned advocate appearing for the petitioner submits that the hearing of the application under Order 1, Rule 10 of the Code of Civil Procedure, which was fixed on 26th of September, has 2024, has been adjourned to
16th October.
16th of October 2025. First up. The learned advocate for the petitioner, petitioner is directed to serve a copy of this application upon the opposite parties by speed post with acknowledgement due and file an affidavit of service on the next date. First up, list this matter list this matter in the monthly list of March.
My lord, kindly fixes a date, my lord. I would kindly fixes a date, my
March monthly list it will appear.
monthly list, my lord, it goes down. It goes down, my lord.
Fixing a
Any
date
date,
will
my
be a
lord, it's
difficulty
a
for the other things.
expeditious disposal, my lord.
You can mention and do that. Yes,
February,
next.
my lord, March. Monthly list of March, my lord has said.
March?
February, my lord.
February monthly list will be published in the next week. Week after.
Grateful, Your Honor.
Yes. Next, call the next matter.
Item number 60, my lord. Item number 60, my lord, I was there, my lord.
Item number?
60, my lord. I was there, but unfortunately,
you did not respond.
My lord, I said I petitioned, but my learner senior.
All right.
Well, I'll be praying for 1 week adjournment, my lord, because
60.
my lord, because I have asked the client to bring me the latest amended plate, my lord. So that it will take time, lord.
You have added the parties.
No, my lord, further parties has been added, and so I've asked the client to bring the latest amended plate. Further parties have been added, my lord.
Then you withdraw this application, file a fresh application. There is no space to add for the parties. I'm giving you liberty. The learned advocate appearing for the petitioner submits that though some parties have been added pursuant to the order dated 27th of January 2025, but he has received instructions from his client that there are several other parties who have been left out. First up, the learned advocate for the petitioner prays for leave to withdraw this application with liberty to file a fresh application on the self-same cause of action. First up, in view thereof, CO 4078 of 2024 is dismissed as withdrawn with liberty to the petitioner to file a fresh application on the self-same cause of action. Yes, next.
65.
অর্ডারটা চ্যালেঞ্জিং অর্ডারটা নিয়ে নিন দিস ইজ মাই অ্যাপ্লিকেশন ফর রেজিস্ট্রেশন মাই
দেখি একটুখানি আগের ফাইলটা দিন তো, লাস্ট ফাইলটা। Petitioner will be at liberty to take back the certified copy of the order appended to the civil revision application upon furnishing a photostat copy of the same. Next. Yes.
65?
হ্যাঁ 65
আগেটা কোন অর্ডার হলো অর্নামেন্টেড
এটা অর্নামেন্টেড 65
মানে 65 legally application মাই লর্ড
Yes.
Order date is 6/7/22, my lord, passed by the Honorable Justice Joy Sengupta in connection with the above mentioned matter. My lord, my lord, fault of the law.
2022, it was dismissed. What were you doing?
kindly heard the main matter
2 years delay.
No, that I have stated, my lord. Your lordship kindly see paragraph. I have stated.
What is the main matter? Come to the main matter.
main matter my lord the draft publication was issued by the competent authority under the Urban Land Ceiling Act. I objected and inquiry report was filed by the authority wherein it appears that no excess land is there. But the final order was passed, my lord, indicating some land is excess. That was challenged before your lordship. I have prepared a supplementary file করেছো? Supplementary affidavit annexing the inquiry report, my lord. কোথায়?
No, you are challenging the order of the appellate authority.
Yes.
Give me a minute.
My lord, supplementary affidavit is there, my lord.
Supplementary affidavit.
Affirm on, my lord, 14th day of March 2011.
2011? 2011?
Yeah, 11 তো দেখাচ্ছে এই তো 11
No, that is not here.
সাপ্লিমেন্টারি অ্যাফিডেভিট ফাইল করোনি নেই দশ তো বলছেন নেই দাঁড়াও wherein I have annexed the, my lord, inquiry report. It is page 15.
Give me a minute.
Well,
One copy is there, my lord. Other copy is not.
আর কপি নেই তোমার কাছে?
Again. The cash card people want to do.
ইম্পিউনারটা কোথায়? ইম্পিউনারটা কই? কোন পেজ? নেই তো এখানে।
थोड़ी हाथ से निकल जाए।
And another dispute is here, my lord, whether the land.
Give me a minute.
Original lead petition to the ইম্পিউনারটা কোথায়?
Cash card.
October 2007।
Yes.
The whether the Bashbagan as classified the land as Bashbagan will come the purview of the, my lord, vacant land. Only 2 point is there. The calculation made by the authority in the inquiry report, I find if I calculate the, my lord, land, there is no vacant land.
So bamboo bushes, according to you, is to be considered as agricultural
Agriculture.
land.
And also here, my lord, I have been given, my lord, benefit of the Mira Gupta's case, plinth area and my lord, land appertaining and additional land also given.
Where you have been given benefit?
My lord, it is, my lord, a supplementary affidavit.
Supplementary affidavit.
This is my copy I am handing over. My lord.
You have given a copy, Mr. Nayak, for the state.
No, I don't have any copy, lord. It's a very old matter.
একটা কপি দাও দিয়ে তাহলে ফিক্স করো। আগে থেকে দাও না কেন?
Yes, give me that.
Calculation is bottom.
Altogether, there were how many plots?
Several plots, my lord, there, my lord. Agricultural plot. Along
Yes.
with my
But
lord.
here, this is the inquiry report.
Yes, my lord.
So inquiry report also says that there is some excess land.
But the calculation was not done properly, my lord. Total land, thereafter, my lord, agricultural land appertaining, plinth area, additional, my lord. My lord, additional land appertaining, my lord, in terms of the Mira
If there is
Gupta's
a mistake in the calculation, you have to apply before the authorities. How can the REIT court decide mistake on of calculation?
No, that I am not, my lord.
But here you have said that the inquiry report was not taken into consideration. Inquiry report was taken into consideration by the
Consideration,
appellate
but
authority.
calculation is, my lord, not properly done.
Calculation part,
And my lord, also, my lord,
you have not raised that issue.
yes.
You have not raised that issue before the appellate authority with regard to the calculation part.
Well, I find from the supplementary affidavit
That
that
point
the
not
calculation
raised,
is,
how can the REIT court
yes,
go
my
into
lord.
that?
Well, kindly
Only
another point, my lord, your lordship, my lord, already, my lord, heard that
bamboo bushes.
bamboo bush is
Bamboo bushes, there is a government order. Where is that government order? Government order has been referred to, wherein it has been specifically mentioned
government
that
order, not that is circular something.
I do not know. That has been considered. This was on urban land ceiling.
Circular.
So, and this
but
has given some reasons as to why the decision which you have relied upon will not be applicable.
That is the State Acquisition Act.
Some reasons have been given. It's not that non-consideration of that has relied upon the show me that there is an infirmity in the
This is
decision.
your lordship, my lord,
There is no infirmity in the decision.
kindly defer the matter to the appellate authority. We shall, my lord,
No,
my lord,
you have to show that there is a mistake. Otherwise, why it will be referred?
Calculation.
Calculation is one part. These are the parts.
Yes.
So, if you cannot show anything with regard to that, with regard to the calculation, if you are liberty, you can approach that.
Yes.
But with regard to this,
Well, that can be.
Mr. Nayak,
Nobody will be prejudiced, my lord. But if your lordship, my lord, held that bamboo bush, my lord, will come in purview of
for that you have to show that. But it is show me the government order.
Government order
Mr.
is there.
Nayak, can you bring that government order?
Because this report.
He is appearing for the state government and urban authority, my lord.
Nothing has been
Next week,
let them show the order.
Next week I'm placing.
Not next week, then we'll thereafter. Better lordship refer the matter.
No. Submit. না কি আনতে পারবে?
Very difficult.
No, my lord, kindly fix the matter after my lord Saraswati Puja.
Apart from that,
He will get.
what my lord, calling from my lord's mind, there are three issues. One, bamboo tree. One is the measurement, another inquiry report and all this.
Inquiry report considered this.
And calculation.
Calculation, according to them, there is a mistake in the calculation.
That part
So,
cannot.
if that part is there, it's okay. But now they are saying about the bamboo bushes. There's a finding recorded. Now, if he is challenging, he has to show that why it is suffers from infirmity. Then
How the circular order
purpose of relegating, I have to record a finding why that finding is not correct. Otherwise, it cannot be remanded because there is already a decision.
I can take
time ne?
but give me supplementary affidavit. Report.
I am handing over the copy of the supplementary affidavit.
Now,
let him take the.
When have you filed the supplementary affidavit? It has not been recorded anywhere.
in 2011, as he is my lord referring to.
My lord, kindly consider Mr. Banerjee, my lord, with me, my lord. He, my lord, forgotten everything, my lord. Now I'm handing over the copy of the supplementary wherein I find that the calculation, my lord.
My lord, এই ঝামেলা রাখিস না, আমি আনতে পারবো না।
করে দেখুন
দেবেন না। Difficult task.
কথা হলো
আসুন।
A difficult task. কেন রাখছেন?
হাইকোর্টের লয়ার কি
আমি লয়ার হাইকোর্টে কপি পাওয়া যাবে না।
Mr. Nayak, learned advocate, appealing for the state pays for an accommodation as this is a matter of the matter is of the year 2008. First up, as prayed for by Mr. Nayak, list this matter after 2 weeks. After 2 weeks na bole na, at a date bole din. 13th of February.
My lord, lordship kindly fix the matter, but it will be very difficult for you with the old matter. Record will not be sorted out.
Record is not
No,
required.
no.
Only circular.
You are filing the case. Why don't you produce that?
Circular আছে দেখ।
We have hundreds of circulars. Very difficult to get it out.
Or you want further time?
Further time may kindly be given. At the same time, lordship may kindly
20th February.
and at the same time also my lord kindly direct the petitioner to produce the same also.
The learned advocate appealing for the petitioner
copy দিয়ে
submits
দাও
that
দুটো করবে জজকে।
no, have you affirmed this? Where is the original copy? Original copy is not in the records.
But no, it is also not in my lord brief. Only copy was there, affirmation is there, date is there, my lord. Kindly see.
Where is the affirmation?
Now date copy in the copy, my lord. Date is there. When affirmed.
For transfer brief, that is the main problem, my lord.
Where have you accepted transfer brief, Mr. Banerjee?
Yes. Without
you have accepted the transfer brief
and without having no
accepted
papers also, is sitting the
all
path
the
of
liabilities in connection with the transfer brief as well.
Your lordship knows mine.
You have accepted the liability also of a transfer brief. You know?
And making state advocate liable, Lord.
As prayed for by the learned advocate for the petitioner, leave is granted to the petitioner to file a supplementary affidavit on the next date.
Yes.
File a supplementary affidavit. দিয়ে দিন ওটা ফেরত দিয়ে।
আমিও দেখছি কপিটা যদি পাই আমার ব্যারাকপুরে অফিসকে বলবো আমাকে যে আসলে ল্যান্ড নিয়ে মামলা হয়
Made on 2000. She kindly give a date. Actually, I'm not advocate on record, so I came for restoration actually. One forensic medical report was medical examination was held on 19th November 2005, but the report was not given to the petitioner.
When you submitted the representation,
On 22nd September 2009.
22nd September 2009. Where is that representation? Page?
Page 50. Annexure 8.
Page 24.
24. Annexure 8. Yes, Lordship. Yes, Lordship. And he was seeking for the report from the medical department.
What was your date of superannuation? November 2009.
Yes, Lordship. Retirement information. এখানে কোথাও
আসুন। The no, petitioner where is your restoration application? (8170) of 2011.
2011, Yes, Lordship.
Oh, this was for recalling of the order dated 7th of June 2011. It was dismissed on earlier. It was also dismissed.
Yes, Lordship. I was not there. At that
Where is your
time.
application for recalling of the order dated 1st of April 2015? Oh, yes. ক্যানটাতে আগে অর্ডার করুন। This is an application for recalling of the order dated April 1, 2015, passed in WPA 21062 of 2009. First of affidavit service filed in court today is taken on record. It has been submitted by the learned advocate for the petitioner. that the application has been duly served upon the respondents. First up, considering the grounds stated in the application, this court is of the considered view that the petitioner was prevented by sufficient cause for not appearing when the writ petition stood dismissed for default on 1st of April 2015. First up, in view thereof, the order dated 1st of April 2015 stands recalled. The writ petition is restored to its original file and number. First up, এবার writ petition order record করুন। The petitioner has prayed for an order not to give effect to the letter of superannuation dated October 29, 2009 on the ground that the date of birth was on the ground that there was a wrong recording of his date of birth in the service record. First up, paragraph. The learned advocate appearing for the petitioner submits that a representation was submitted by the petitioner dated September 22, 2009, praying for correction of the record of rights, correction of the date of birth in the service records. The paragraph record reveals that the Deputy General Manager within bracket personnel, Urisa Mineral Development Company Limited issued the superannuation letter dated October 29, 2009, informing the petitioner that on attaining the age of superannuation, he will be retiring from the services of the company with effect from 15/11/2009, and the petitioner will be released from service of the company with effect from November 30, 2009, being the last working day of the month. First up, it is not in dispute that the petitioner submitted a representation praying for correction of the wrong recording of his date of birth in the service record at the fag end of his service career, that is 2 months prior to his date of superannuation. First up, it is well settled that representation praying for correction of date of birth in the service record shall not be entertained at the fag end of the service career. In view thereof, this court is not inclined to grant any relief to the petitioner. The writ petition stands dismissed without, however, any order as to costs. Urgent photostat certified copy. Next.
67.
I am on behalf of the advocate on record in this matter, my lord. Very short matter.
Restoration application?
Only restoration application.
Only restoration. What is the main matter?
Matter
What is the main matter?
Matter is the service matter of the cooperative society, the member of the cooperative society, so the railway canteen.
What have you prayed for?
Prayed for the observation of the about 54% are there, 6 or 7 are absorbed, but others are not absorbed. So grievances is there. All the grievances are, the restoration is only on 18th January in this year. I am
absorption.
After absorption, my lord. So that
where is the scope for absorption?
That is already appointed already. So that point, if you that is quite matters if you lost accommodated once you for main
for the railways.
for main matters, if you appoint
Who is appealing for the Union of India?
Union of India. I have the copy. They are waiting for
Who is the learned advocate?
Mr. Shamal Ghosh. Sukanta Ghosh and Mr. Shamal Ghosh already submitted, waiting for before.
He was waiting.
Yes.
All right, I'm passing it over. Inform him. Yes, pass over. Next. Call the next matter.
69.
Pass over.
Oh.
I beg to appear on behalf of the lead petitioner in this matter.
I am for the respondent number 4 workman. I am
Respondent number 4?
It is an
is disputed relating industrial tribunal.
my lord, the industrial tribunal.
State legal service authority leading.
My lord, we have challenged. My lord, there are two applications pending before the writ petition may be
What are
taken.
those applications?
My lord, those applications have already been disposed of because one is for review. Another application was taken out by them as we have not followed the order which was passed earlier by this honorable court. Thereafter, that order was recalled in the review, and my stay, which was operating at the time when I moved this application, it has been again operated. It has been again
What is
operated.
the order under challenge in the writ petition?
Well, the learned industrial tribunal has held him as a workman, which we have challenged, and thereafter said there is no proper evidence that he has able to give before the industrial tribunal in order to show that he is a workman. There is no salary register being maintained. There is no employees provident fund that he can able to produce. There is no other attendance sheet. It was just that he was just well acquainted of the writ petitioner. He used to come and sit in the in his Howrah sawmill, his factory, and he used to work regarding that. Only on the basis of an 144 report which was filed by the police officer, where it has stated that he is a workman, only on that basis the learned tribunal has proceeded that he is a workman, so he should be given a salary from the date when he has last attended his service, and from when thereafter I have not allowed him to be continued in the service. That is from the period of 22nd June 2012. And
what are the documents on the basis of which the learned tribunal has arrived after finding that he is a workman?
Salary receipt which is issued by him. Salary receipt belongs to not of the Howrah sawmill, not of his employer. Salary receipt which was given by the employee himself, Chittaranjan Devnath.
Who paid the salary?
We have not paid any salary. We have actually not given any salary.
You have not engaged him.
We have not engaged him. There was no evidence that he could able to produce before the learned tribunal in order to show that he is an employee of our concern. So thereafter, after the order was passed on October 2019, it was only on the basis of an 144(2).
Writ petition copy. Writ petition copy. So the writ petition.
My lord, the affidavits are complete, and my lord can fix up this matter at any day because I am led by Mr. Shomu Mojumdar in this matter.
All right. On the prayer of the learned advocate for the petitioner, hearing of the matter stands adjourned for the day. Next.
Well, the two applications may be taken out from the list because those are not yet been, those have been already been disposed of. Two applications also been
Can 2 and can 3?
Yes.
Dekhe nin to.
Those are already disposed of.
order record kore deben.
Those are already been disposed.
Can 2 or can 3 একটু দেখে নেবেন. It has been submitted by the learned advocate for the petitioner that the applications have been disposed of. In view thereof, the department, the register IT is directed to ensure that these applications are not shown to be pending in the docket of this honorable court. একবার দেখে নিয়ে তারপরে এটা
Mr. Shukanta
তারপরে
tomorrow is not available due to personal difficulties. Only I pray for accommodation for 2 more.
Then next week করে দিন. Next.
Grateful.
You have the date of the order when these applications were disposed of. Please supply the date of the order. Yes, call the next matter.
Okay, I will supply.
70.
But I am appealing on behalf of the petitioner. On the last occasion, your lordship directed me to serve notice upon the other side. But
yes, you have served.
Yes.
Yes. What is
But-
your prayer?
My prayer is, before that, I filed an supplementary affidavit. But the only question is the pay slip, the exhibit 4 and 4.1. But that has already been annexed in the writ petition page 80 and 81.
Which order you are challenging?
Challenging the page, order of computation. This is
31st of March 2021.
Yes.
Page.
The page 85, start from 85.
This is 85.
85. After this, on the page 85, the last portion, after receiving the summon of the opposite party company, enter into appearance for this court, but failed to file a written statement. In spite of several opportunity given to the company, ultimately the
Yes.
case.
What is your instruction with regard to the documents which were placed before the learned tribunal?
Page 80 and 81. That's already annexed.
Page 80 and 81.
80 and 81. And then subsequently, I also given to the respondent for notice to produce of the document. But that also received by the authority. But in spite of receipt of the notice to produce, but that I already filed and supplementary affidavit today. But in the page 80, Auraj Singh, he received 15,724 in the year 2013. And Ramjit Singh.
When you were terminated?
1985. My appointment in 1979. I have been not terminated, dismissed in the year 1985 only on the ground for creating the
No, you have produced your salary slip for the month of July 2004.
No, that letter has been produced by the company.
Who is the applicant? You are the applicant.
I am the applicant.
So you have produced. Kindly come to page 86, last paragraph.
In the instant case, no payslip of the applicant has been furnished by the workman to substantiate his monthly wages of rupee 2070. But Exhibit 6, the letter dated 9th August 2004, disclosed the fact that for the month of July 2004, workman was paid rupees 1070. This Exhibit 6 has strongly corroborated the claim monthly wages of the applicant to the tune of rupee 1070 only prior to the termination. But The applicant in his claim amount demanded yearly increment of rupees 600, contending that yearly increment comes within the purview of the consequential benefit as awarded by the learned Third Industrial Tribunal. Surprisingly, no document has been submitted by the workman to show that his yearly increment of rupees 600 600 exhibit 4 and 41 are the payslip of two different workers. Learned advocate for workman tried to convince this court that those workers are junior to the Sri Jonathan Singh and the pay scale Sri Jonathan Singh should be higher than that the Awara Singh and the Ramjit Singh who payslip have been produced before this court. The date of joining of those two workers, 2004, there is no question of any payment in favor of the petitioner. He has been dismissed in the year 1985, the Annexer P1. That document should be another workman or otherwise.
But you have produced this. It has been recorded. You have produced
but
this.
that amount has been received before dismissal in the year 1979 to 1985.
For the month of July 2004.
That has been another.
Kindly come to this page 86, furnished by the workman to substantiate his monthly wages of 1070.
Well, that is the 1070 has been substantiated on the basis of the slip letter produced in the another workman.
No. Where do I get that? For which workman? Show me. Show me the payslip of that workman of 1070.
Well, if your lordship kindly call for the lower court,
No.
Otherwise it is not possible because
calling for the records will not be ordered. If you can produce those documents, because this is the finding, you have to show that there is infirmity in the finding of this.
I also want to submit a notice to produce of the document by way of supplementary evidence.
That is neither here nor there.
Yes. But the workman salary should be substantiated by the company itself.
What was your payslip in December 1985? Show me.
My payslip 1985. That has been admitted by the company.
What was your salary in 1985? What has been admitted?
1070.
No, this is of July 2004, not of 85. This is July 2000.
In the year 19...
That has been recorded. That has been recorded in the order.
1985, I was dismissed. Question of 2004, the space
that is the recording. Then you apply for correction of that before that tribunal. This is the recording of fact. And it has been recorded that you have produced that document. This is the specific recording. Kindly come to page 86. That was exhibit 6. Where is that document, exhibit 6? You have produced.
Well, that document is not with me at this stage. If your lordship, I take up instruction regarding this pay slip. If your lordship kindly adjourn this matter.
All right. The learned advocate appearing for the petitioner prays for an accommodation to enable him to collect the documents from his client. Let the matter stands released from the list. Let the matter go out of the list with
kindly
pray for inclusion after all the papers are received from his client. Yes, next. Call the next
not go out of the only 1-2 days time. My client is my
was granted on the last occasion
in my chamber. My client
recording in the order itself.
My client is here.
That will not help. Time was given to collect instructions.
I already instructed supplementary affidavit on the basis of that file. If you also kindly not go out of the list on 1980,
collecting all the materials.
1985 matters. If you lordship kindly take up to 1 or 2 days time, I will supply all of the documents.
Next week.
Next week. Get full lordship.
Yes, next.
71.
My lord, this 67 is opposite party is there, my lord. That restoration application.
What is the item number?
Item number 67.
Yes.
67.
Application for restoration, Lordship, within time. So I will
Main matter. No peaceful
Lordship,
hearing in this court.
Lordship, may kindly, Lordship, because that we have filed our opposition and pleadings are ready, Lordship. That
What is the matter about?
Lordship, may kindly that Lordship, kindly
Then
allow.
not today. Get ready with the main matter. Yes, next.
Seventy-one.
71, I appear for the respondent number 2, my lord.
Lordship, I have been requested by the AOR for the petitioners.
Not today, next.
My lord, I am suffering because of the pendency of this writ petition. They have to.
Why?
My lord,
Is there any interim order?
There is an interim order.
All right, not today, only next occasion. Yes. For the next matter.
Grateful.
72.
Mr. Nayak, you are appearing.
I appear for the register lordship in this matter, not for the petitioner.
Not today, next.
Petitioner is some
73.
Not today.
77.
77.
Yes.
I'm for the petitioner, Lordship. Better.
But this is the matter.
Better.
When during the course of hearing, they offered for direct purchase. Accordingly, they agreed to that. And your lordship categorically directed them to file an affidavit to that effect. Not I have been served with the affidavit. And I'm sorry to go through the affidavit. Not I am not agreeable to, my client is not agreeable to this. They put the condition and saying that as and when the recording body will place the fund, they will thereafter, after 2 months, they will do this.
4 months.
All right. So, next day.
Next.
Next tomorrow. Tomorrow.
Not today.